committee on two matters, and Mrs. Mesado is the one who has conducted that research.
Please
So,
go ahead.
Okay, great. Thank you, Chair. So Mrs. Mesado is the one who will present.
All right, Mrs. Mesado, please go ahead.
Yes, Chair. Thank you, Chair. Good afternoon to you, members and colleagues. The first outstanding issue that I wanted to address was the matter of whether there were any timelines in the jurisdiction in the legislation in other jurisdictions for the employer to be required to take the appropriate and immediate action that we were talking about. When we looked at the other legislation, we only found one instance where similar terminology was used. I believe that was in the Belize legislation. So they also required immediate and appropriate action to be taken by the employer. However, they did not stipulate any time frame or any timeline within which the employer was to act. And we also found in the Barbados legislation, that's the only instance where we found that timelines were stipulated. So it was 2 days for the employer to inform the accused of the complaint and 14 days within which they should start the investigation. So with respect to timelines, only Barbados had timelines and Belize had similar terminology that we have for immediate and appropriate action. So I'm not sure if any of the other technical persons found anything else, but that is our findings with respect to that matter. Then there was a final matter that we were looking at, the definition of a person in charge of an institution. And in our findings, basically we have found nothing, no definition in any other jurisdiction for the person in charge of an institution. So that is our report.
Chair, you're muted.
Thank you. Yes, I was having a little difficulty coming off mute. All right, thank you. Was there any other? Well, maybe I should invite comments at this point. In terms of timeline, Senator Campbell Rodriguez, you wanted to make a comment on this?
Thank you, Chairperson, and thank you, Ms. Mesado. So we really haven't found anything in terms of timeline, but are we, Madam Chair, still opening to putting a timeline in our bill? Because I would support us still putting a timeline in place to define immediate and appropriate.
All right, I'm going to ask Senator Donna Scott Motley, you have a comment here?
Just a moment, Chair. I'm trying to put on my video.
Oh.
Chair, the remark had been made. Thank you, Chair. The remark had been made that in Belize, there was a 2-day timeline for the employer to advise the accused, for the want of a better word, of the complaint.
And Barbados is done.
Barbados. Yes. Yeah. I shouldn't have forgotten that. 2 days, and I think that is appropriate. I think that's a good timeline because I think that has an element of immediacy, but takes into account anything that might happen that, you know, gives a window of opportunity. So I would think that 2 days should be adopted. I agree with Senator Campbell Rodriguez that we should have a timeline. Thank you, Chair.
Thank you, Senator. Senator Hale?
Good afternoon, members and colleagues. Thanks, Chair. The only concern I have with respect to the timeline in terms of notifying the accused is you may have a situation where that accused might not be at work in the case of employment. Say the accused may have been on sick leave or vacation leave. So within being notified of the issue or the complaint, to notify within 2 days as a prescribed period. One would raise a concern if you notify an individual when the individual is not at work.
Thank you, Senator Gale. I'm going to ask Senator Minister Johnson-Smith. You may wish to make a comment here.
No, thanks, Madam Chair.
I'm sorry?
Madam Chair, she said no thanks, but I would like to, because I take into account what Senator Gale has said, but there are many ways to notify persons now, which have been accepted. Even in terms of our civil procedure rules, we acknowledge that you can notify somebody by email and it's acceptable and so on. So I want to ask him if he thinks that if he's considering that the communication should be face-to-face, and that is why he's raising that.
No, I don't think it ought to be face-to-face. But we treat this as a means of possibly starting disciplinary procedures. Let's treat it against that standpoint. And in the normal course of things, such an employee, in the case of the workplace, would normally have been advised when they are at work. And so someone may say, Senator Scott Motley, that I was not at work and I did not receive the communication.
Not to say, but remember, we have discussed, we have discussed at work, although it does not, this does not address what immediately what you are saying. We have discussed at work, and we have agreed in other clauses that at work does not mean present at a location. So I don't think that would be an appropriate response from the person, having regard to the way the entire bill is crafted, where we know that work is broadly defined, workplace is broadly defined.
Well,
I guess we can all make a decision on that point.
I'm just raising my concern in terms of what a possible response may be in light of that situation.
You see, Senator Gale, I think we need to signal in the bill just how urgent these matters are, and that the employer must take it very seriously in terms of acting swiftly.
Yeah, man, I have no difficulty with that, and let me make that abundantly clear. I have no difficulty with that in terms of taking the appropriate action within a defined period. I'm just raising that particular concern, and it may not happen, but it may very well happen.
Senator Gale, would you want to suggest a different timeline?
No, I have no difficulty with timeline, Timeline is not the issue. It's just that I'm just raising the concern that the person might not be at work at the time when the communication is given. And normally in the course of things, in terms of communications to employees, they never normally respond to communications when they are on either sick leave or vacation leave. And it might require, in terms of an internal policy mechanism, for the persons so communicated to respond.
Well, can we get some guidance, Mrs. Masado, or from SG, how we would frame this, taking into consideration the concerns expressed by Senator Gale? SG, Mr. Masado, or Ms. Grant?
I'm so sorry, Minister. Chair, I apologize. Sorry, I got a little distracted. Sorry, can you just repeat the point, please? So sorry.
Now I was saying, SG, that where in the Barbados legislation, it gave a timeline for 2 days for the employer to communicate to the accused. I raised the concern against the background in a situation where the accused might not be at work at the time, in cases of they may be on vacation leave or on sick leave. And if today being Wednesday, the complaint has been made, there's an anticipation that by Friday, you must inform the accused. And so what would happen if the accused is not at work? If the accused was on vacation leave, if the accused was on sick leave, and this is only in relation to the workplace scenario, and where that accused may indicate that they were not at work and so they were not privy to the communication.
Sorry though, Senator Gale, I thought that the whole issue with the urgent and immediate action was in relation to clauses 5 and 6. Is that what you are referring to? Clauses
No,
5 and 6?
I was referring to what Mrs. Masada would have indicated in the Barbados legislation for the timeline to communicate to the accused of within 2 days.
I understand, but we have to then put back the timeline in the context of our bill. And I'm saying in our bill, the issue of urgent and immediate came up in clause 6.
Yes.
And it's also in clause 5.
5 and 6.
Right. So when we are looking, so we were just looking at timelines that we saw generally, but you would have to now go back to what's in our bill and what would be required as a timeline. So, meaning instead of using the words urgent and immediate, we would be putting in specific days instead of using the words urgent and immediate. That is what I thought was being discussed by the committee, and I thought it was in relation to clauses 5 and 6, but I could be wrong.
No, man, you're quite correct, you know.
Okay.
What the clause represents is for the immediate action or the appropriate action to be taken action by the employer, right? Let's start with that.
Okay, so the issue then is, what is this appropriate action? Because it may not mean, so I know you are looking at advising, informing someone, but there can be other things that can be taken during the period. There can be other action that's taken, not just to inform or advise the employee. So I was going to go further at another point to say that I think there's going to, if you're going in this direction, which is good, it's fine, you would have to though be specific about the timelines and what action it relates
and what
to.
that action would be. So in the Barbados case, the suggestion was for 2 different types of timelines. 1, to communicate to the accused, and 2, within 14 days to treat with the matter. Right?
Okay, so as it relates to then communication with the accused.
Right. And that's the only one that I have a gray area.
And you have been right. So as it relates to notice being given, remember, we can put in a provision to allow for electronic notice. So it doesn't have to be notice given to someone in their hand. It doesn't have to be physically given to them. It can be done electronically, and we're doing that a lot more now in a lot of our laws. And in fact, it was actually being accommodated from 1999 with the Electronic Transaction Act that nobody seems to be aware of. But be it as it may, we're now trying to again insist on that, and we're putting it in a lot of laws. So that the 2 days would not be unreasonable if you allow for electronic notice being sent, because electronic notice.
Through you, Senator Gale raised the point in terms of maybe persons who might be on vacation. Electronically.
One moment, please. Yes. I'll just allow the SG to complete, and then you can raise your point. Go ahead, SG.
Right. So even if action is being taken against an employee, it doesn't really, usually we don't look to see whether they're on leave or not. Um, you can send a notice whether or not the person is at work or is not physically at work, whether they are on leave or not. The issue is whether they will receive the notice. So electronic communication can be given whether to a private email address, a work email address, can be sent over the phone. And these are things that we do even for other things. So for instance, even the court, even with the court, we're doing electronic transmission of notices. So to me, the 2-day timeline wouldn't be a factor if you allow for electronic communication. If you're doing it by mail, then I think you may need a little more time.
Okay, Senator Longmore, and then Senator Scott Motley, your hand is up, right?
Yes, yes, Chair.
So I'll just take Senator Longmore.
Thank you, Chair. I was just trying to bring to the SG's attention the circumstance when she said by electronic means that a lot of times persons who are on vacation, sick leave, they have an automatic thing set up where they're not able to receive, they're on vacation and they're not able to receive emails. So I don't know if that is in consideration with her response. Thank you.
May I make an intervention now, Chair?
Please
You're
go
on
ahead.
mute. I want to add to what I've said by pointing out that it's not the employee who will be sanctioned. It is the sanctions apply to the employer if the employer fails to take this immediate action. So if the employer sends the mail electronically, the notification electronically, and the employee does not see it within the 2 days, there are no consequences for the employee. It is the failure of the employer which is made, for which if he fails to do that, then it's the worker. If you look at 5.2, it is the worker who can therefore make a complaint to the tribunal, but it's in respect of the employer, not the employee. So I think that Senator Gale, your concern, I understand and I appreciate, especially since you are there to protect the workers. But I think in this case, looking at 5 and 6, I think it's the employer who would suffer the consequences, and the act requires that the employer takes these matters very seriously.
No, Senator Scott Motley, I agree with you.
Oh, but I'm just pointing out employer. So
yes, man, and I agree with you. My only concern, and it may just very well be a concern, where the action taken by the employer does not create a consequential demand on the employee within reason.
That's what I'm saying, that I'm not seeing that. But I would ask, it might be the Solicitor General can advise me. I'm not seeing where there is any consequence to the employee. I'm not seeing that. I'm seeing where there are consequences for the employer.
Well, how the bill is crafted, the consequences rest entirely, in this case, on the employer to take action.
Absolutely.
What I just want to bring to the table is that we don't want a situation where, having notified the employee, you expect the employee to respond in an internal policy mechanism within a defined period if that employee is not able to. And that's what I meant by the consequential action that may very well bound the employee. But I'm not suggesting in any way, shape, or form that I am not on point with what is being required of the bill. I'm only pointing out the reference of an impact that may be created on the employee. Nothing to change with the bill. I'm in agreement in having timelines, but I was just merely pointing it out.
Yes.
Okay, thank you, Senator Gale. SG?
Yes, it's just a follow on from on the same discussion, Chair. So thank you. Just to point out that the employee has 12 months within which to make the complaint. I'm saying that in the context that if a notice was sent and there is some follow-on sort of action which could lead to the complainant, the employee making a complaint, they have a year. So I don't think sending them the notice would in any way prejudice them. I can't see how, especially
No.
since they have a year within which to
No,
make
this was in the
complaints.
case where the employee would have been the accused, not the complainant.
Okay, so again though, there would have to be a reasonable time given to the employee, the person who against whom the complaint is made, to be
Yeah.
able to respond. There has to be a reasonable time given to that person.
Okay.
And that person would and there's a lot of case law and all of that you couldn't expect them to respond overnight. If you have not been able to reach them, then you would really have to make all good efforts to get to them and give them an opportunity to be heard.
Okay.
All right, thank you, SG. Ms. Grant?
Yes, Chair. I was just trying to follow the conversation. So I don't think I managed to capture what the committee agreed to read the timeline. So which timeline have we agreed to go with as it relates to communicating the information to the accused and the amount of days for investigation to take place?
We haven't actually agreed to a timeline.
Oh, okay.
I think we now need to agree to a timeline. And Senator Gale, I think you may want to comment on this since you had all this.
On proposing a timeline, Chair?
Well, there is a timeline on the table that we were discussing, but you were expressing some concerns.
No, man. The concerns, I believe I would have ventilated the concerns, and I believe there's some sort of an understanding around why I would have raised the concern.
Right. All right. So at this point, then we need to, do we agree that we need to have a timeline? Is that the feeling of the committee? We should state specific timeline.
Sorry, Chair, if I may just suggest that perhaps for clause 5 and clause 6, to me, I think it would be better to have two separate timelines, so to speak,
Yes.
because the immediate and urgent action, like the 2-day timeline, wouldn't work as it relates to certain other actions. So it could apply, for instance, if you're going to be notifying someone of a situation or so, but not to, for instance, do an investigation.
Yes.
I think the 2 days, what is being suggested for 2 days you'd have to be clear about that. And
Right.
for the other actions, you'd have to be clear about those as well.
All right.
I agree with the SG, Chair. We would have to have the 2 days couldn't apply across the board for all the actions. But I was thinking in terms of giving the person who is being complained against notice that the complaint has been made for the 2 days.
The 2 days.
Which was what I understood the Barbados legislation to be saying.
So in this case, we agree that we could give 2 days. We could agree to that. 2 days.
Well, I think I have expressed my view, Madam Chair, so I guess it would be for the others to say whether they want to leave it at large with the immediate and appropriate as it is there, or to put in the time frame.
Yes. So if I I'm not receiving any other comments. Do I?
Yeah, Madam Chair.
Okay.
I was just about to jump in and say.
I recognize Dr. Angela Brownberg and then Senator Gabriela Morris.
Okay, thank you, Madam Minister. I just want to say that I too agree with the Surgeon in terms of being clear about the timelines and what they refer to. And I also agree with the notion that to, for example, inform the person against whom the complaint is made, 2 days is sufficient. But then we just have to be careful in terms of the rest of, 5 to 6, in terms of what period we would think would be appropriate for those.
Okay, thank you. Senator Morris and then Senator Campbell Rodriguez.
Yeah, yes, Chair. I just wanted to also support that I see the need for a timeline. I wasn't totally clear though. I might have missed this bit about the 40. I heard something about 14 days being given. I'm not sure what that was referring to, but I do agree with the 2-day timeline for giving a person notice.
Okay.
I just wanted some clarity on that.
Okay, fine. All right, we'll go back to the 14 days. I just recognize Senator Campbell Rodriguez. There are comments on the 2 days.
Thank you, Minister. I'm in support of the 2 days for the employer to give notice to the accused. And in terms of the 14 days, I understood the 14 days to be the time within which the employer has to start acting. And I am in support of that 2 weeks as well for the employer to start acting to resolve the matter. Okay, but I will take guidance from the technical team if they think the 2 weeks is enough.
Thank you, Minister Johnson Smith and then Senator Fraser-Binns.
Thank you, Minister. I just wanted to get some clarity around that 14 days. I'll say I support giving a 2-day period for notice to the accused. But I really am quite hesitant to start to become more specific about timelines in respect of immediate and appropriate actions, because there is no end to the possibilities of, to the variable circumstances within which harassment could occur. And I wonder if we start to try to specify appropriate timelines for particular actions in particular circumstances, that we will create loopholes inadvertently and also allow for that creative compliance. So, you know, once you have done X, you have ticked the box, but what you have done is not necessarily appropriate in the totality of the circumstances. And it's not necessarily helpful in bringing justice, but it is having done something on a list of things to do. And I think we have to guard against that. I understand and appreciate and agree with the need for certainty as much as possible in legislation. But I think sometimes you can try to over-prescribe and you know, the law of unintended consequences takes effect, whereby you then create loopholes and you don't necessarily get the result that you're hoping for. So if we need we need clarity, but we need flexibility, because we are expanding the range, the ways in which this act can be applied. We want it to be in the environment in many different circumstances. We want it to encompass as many ways in which a person may feel offended and aggressed by unwanted advances. And we want to ensure that the framework with which employers are able to comply or must comply is one in which can be adaptable and scalable for persons to understand that this is something that we expect to not only be for the big corporate entity or for the government enterprise with, you know, strong regulatory compliance departments, etc. We want it to be understood that at every level, what is appropriate and what is appropriate for your circumstances can be effectively implemented. So whatever type notice needs to be communicated and whatever action needs to be taken, whether it is in respect of a third party, which we have discussed as well, as opposed to an employee or a colleague. I think if we become too prescriptive around timelines, we could create problems instead of solutions. So I would just express some hesitation on my part about going very far in terms of trying to parse out what immediate and appropriate means in all its circumstances for 5 and 6 and otherwise. Thank you, Chairman.
Thank you, Minister. I want to recognize at this time Senator Fraser Binns and then the SG. And I really would like us to at least make our decision on the 2-day notification. I think the 14-day matter is something that we can discuss after, but I just want us to agree that notice should be served within 2 days. And then just to get the comments on that, and then our guidance in relation to the 14 days where, as Minister Johnson said, we start prescribing those specific timelines, we could end up into, sort of a straitjacket situation. So I'm going to recognize Senator Fraser Binns and then the Solicitor General.
Thank you, Minister. Good afternoon, everyone. I'm happy I spoke after Minister Johnson-Smith because the second point I had really is in keeping with what she mentioned about us being prescriptive. And I wondered whether the 14 days that is being proposed has to do with the 14 days for completion or the 14 days for commencement. And I too would like some clarification around that. I have no problem with the 2 days. I just want to find out, and perhaps the technical team can guide us. What happens in an instance where the 2 days, when the complaint is made, for example, on a Friday at 4 p.m., is it that the employer is required to give the notice by the Sunday, or is it that the employer, the time starts running as at the Monday or the Friday? So I would like some clarification in that regard.
Solicitor General, SG, could you?
Sorry, Chair, I was just having a technical difficulty. Couldn't find the mouse and couldn't find the buttons. So to deal with the last issue first, raised by Senator Fraser Binns about the 2 days. So you would use the Interpretation Act, Section 8, and I just pulled it in terms of how you count days. And when in the act. So you don't count weekends if it's less than 6 days. So that would be the first thing. So if it's Friday, you wouldn't count the weekend. So the scheme in Barbados, granted, I think they're also a criminal sort of statute, but the scheme would be 2 days to advise the offender. 2 days given to the employer to advise the offender, 14 days given to the employer to commence investigation, not to conclude, to commence. I would have also suggested that you would need other words. So maybe you'd go back to the urgent and immediate to deal with all other matters, because there will be other appropriate action or other action that will need to be taken that you would not be necessarily outlining in the legislation, but you would still want some sort of timeline for that. And if those actions are going to be those that we don't specify, then maybe it's best you go back to those words of taking immediate action or urgent action. But you'd need to have some other sort of timeline for the other types of action that would be taken. So for instance, it may be sensitization to staff. It may be, there could be a variety of things that the employer needs to do based on the allegation that has been made. And you wouldn't want to just leave it without any sort of timeline either. I'm not sure if there was anything else I was to respond to.
I think that your response, SG, covered the questions that were being raised. So at this point, I would say that I get the sense that we agree on the 2 days where the employer would have to notify. The 14 days, I get the feeling that we do not want to prescribe 14 days and tie ourselves into a situation, but rather to keep urgent and immediate action, something to that effect. Ms. Grant, can you make a comment here to see if you have sort of gotten the sense of what the committee would want to do?
Yes, Chair, I think so. So that the 2 days, at least for the accused to be notified that a complaint has been made against such a person, and to keep immediate and appropriate for commencement of investigations instead of being very prescriptive, so as to not so contain ourselves.
Mm-hmm. So members, we agree on this. So, if we agree, can we move on? Senator Gale?
I see member Witter raising a concern in the chat room.
So Senator Witter is saying, concern in relation to timeline and how this would impact the informal workplace that may not have the necessary technology. I don't know. I think the 2 days notice would still work there somehow. Ms. Grant, you have a comment on that?
Minister, I think the 2 days could still work, especially even though an informal setting might not have the necessary technology. Based on the trend of the discussion as I was following, it didn't seem to me that use of the technology that we're mandating, but we're saying that certainly it would be faster if you had access to the technology to just inform that a complaint has been made against you. So I think that the 2 days could also work.
So Mr. Witter, you could indicate if you're fine with the 2 days. You may have a difficulty communicating other than through the chat, but I think that we could work with the 2 days and not prescribe 14 days for action. Do I have the agreement of committee here, Dr. Angela?
Sure. I just wanted to ask, Minister, as I said earlier, I'm okay with the 2 days to notify the offender. I am just trying to think of conceivably what could be the reasons why an investigation could not start within 14 days. Understanding all the different individuals involved from which a statement or the investigation would be made. And I mean, I'm thinking of it against the background that if I am the aggrieved and for 2 weeks, I do not see any movement, anything, maybe not even a more fulsome statement than the initial one that I gave, nothing. How would that impact that sense of security and protection at the workplace? I'm just wondering, it's not to complete the investigation. We're not prescribing a time by which it should end, but to say that in 2 weeks you would expect, because that's how I understand it. In 2 weeks, we would expect to see the investigation begin or to know that the investigation has begun. So I mean, I am to be guided, but I'm just wondering what could conceivably prevent, an employer from beginning in 14 days.
All right, Thank you, MP. I'll take this Mr. General's comment and then Senator Donna Scott Martley. SG? SG, I saw your hand up. All right, I'll take Senator Donna Scott Martley and then come back to the Solicitor General. Yeah.
Chair, I just wanted to have the Joint Select Committee look back at 5. And I asked the question, if it provides for the worker to have recourse by making a complaint to the tribunal, should we not need a timeline so that the worker has a sort of guide as to when it is that the employer has failed to take action? Now, the clause requires that they take immediate and appropriate action. It does not say that the investigations or the processes should be completed within a particular time. But I think in an instance like this, where provision is made for the worker to go to the tribunal and make a complaint, the clear intention would be to want the employer to act speedily. And that is why I think that a timeline in terms of when the employer should commence would be appropriate. So that if the employer fails to commence within a particular time, if you even want to say a month, then the worker can go to the tribunal and say, I am not satisfied that the employer is dealing with this appropriately, bearing in mind that we are trying to protect persons within the workplace. So I would like to put that out for consideration, Chair.
Senator, Solicitor General, Mrs. Aldred, you want to?
Yes, I really apologize again. Sorry. Okay. The reason I'd raised my hand earlier, and just let me take it down while I speak, was just to also bring to attention that if the committee is agreed on the 2-day timeline, you would also need to put in a provision for electronic notice, because that's not in the bill. So that's another issue that you would have to raise with the members' chair to take a decision on that. As it relates to the discussion going on, I just wanted to get the opportunity to read the Barbados legislation fully, because it's not just a matter of providing notice to the person against whom the complaint is made. So if you just allow me, it's in Section 8 of the Barbados legislation, where a complaint is lodged with the employer under Section 7, the employer shall, A, in the case where the complaint is made against the employee, inform him in writing of the complaint and its details within 2 work days. So it's not just to say there is a complaint, you also would have to advise of the details of the complaint. B, in the case where the complaint is made against the client, take such action as he considers appropriate in the circumstances to bring the matter to the attention of the client, and commence investigation of the complaint within 14 days of the complaint being lodged, and shall complete the investigation without delay. So you'll see that it spoke of not just commencing within a specific timeline, but then also provided guidance for the completion of the investigation, and the guidance was that it should be done without delay. There's one follow-on that I was trying to find out, because the thing is, when you advise a complainant, advise the alleged offender of the issue, what else would you expect that person to do? But I think it may be too early for them to be doing anything, because you're telling that person, look, someone has filed a complaint against you, but then you as an employer would still need to have time to undertake your investigation, which is why I think it's structured that way in Barbados, just to advise that a complaint was made, because it's your right to know, and then just to give you provided the details of that complaint, and then the guidance from the legislation is investigations should be commenced within a certain timeline, and then they should be completed without delay. So I just wanted to bring that to attention, and of course to ask you, Chair, to bring to the attention of the members that you may have to take a decision about inserting a provision regarding notice, because if you don't, the Interpretation Act applies, and that notice is the post.
Okay, SG, thank you so much. So members, you have noted the points raised by the Solicitor General. Senator Gale, please go ahead.
I just want to ask SG, in terms of the notification and providing details, because this provision of details might very well mean that, you know, it's this detailed in nature, maybe descriptive in nature. Is it just to notify that you have been accused of sexual harassment by such and such? Or would it require sufficient detail that would have been provided maybe in a report by the accused?
SG?
And I'm going
By the
based on what
accuser.
would have been by the accuser. Sorry. Thank you, Dr. Angela
No
Brown
problem.
Burke.
And I know why Senator Gale is going down that path as well. I understand. Because the issue is how much information are you giving the person to whom the complaint against whom the complaint has been made.
Has been made.
Right. So from what I'm seeing here, it just says details. And for me, it would have to be sufficient detail for the person to understand what the situation is. So it would, if the information, whatever is provided to the employer from the complainant, I would suspect should be detailed enough to give, for instance, a location, a date, the actual allegation, what happened. We would have to look a little further to see if there are any regulations or anything under this law to tell you exactly, to flesh it out, to see exactly what they mean. But I would think the basic information that would then let the alleged offender know exactly what is being alleged, because then what would be the point?
Right.
Ms. Grant, please go ahead.
Yes, Chair, I just wanted to say, as it relates to the insertion of the electronic notice provision, that if the decision is taken by the committee to insert such a provision, then it would take us back to what MP Whittle's concern. So if it's inserted in the legislation that within the 2 days notice should be sent electronically, then it would take us back to instances where such technology is not available in informal settings. So I just thought I'd raise that for consideration.
Sorry, can I just ask what technology? You're talking about a phone? It doesn't have to be a laptop. It doesn't have to be a computer. Right now, even tax information, and you can get notices via text.
Yes.
It's in law.
So okay. Because I think when it was mentioned initially, the impression possibly was that it was by email. And so I think that was the gravity of the concern.
Well, there are various means: text, email, WhatsApp, All right. So at this point, members, I would really like, us to come to some decision as to where we go from here. We go with 2 days notice by the employer. We are, I know there is still an interest in looking at the 14 days or a specific period of time for action to be taken. I think at this point, what I'd like to do is to suggest that we come back to this at some point and just ask Ms. Grant to complete the general recommendations before we tidy up specific clauses. Ms. Grant, if everyone agrees to that, can we proceed?
No problem.
Fine, I take silence as consent. Thank you. Please go ahead, Ms. Grant.
Not a problem, Chair. Afternoon, members, colleagues. I'm just going through what is left of the general recommendations, and they are not many. The last time we dealt with some of the recommendations that were raised by Jamaicans for Justice, and I don't believe there was a decision as to this provision, so I'm putting it back. They suggested that a provision be inserted in the legislation which requires each member of the Sexual Harassment Tribunal to undergo mandatory training prior to assuming functioning roles on the tribunal. All right, and I'll just read the next recommendation, and these are the recommendations on the Matrix 2. This comes from Awoja to say compensation to be provided for the provision of therapeutic support to be paid by the offending party once found liable on behalf of the victim. And I also want to put, Chair, I don't remember, it had been discussed. I don't recall if we had made a decision about it, about how to treat with concurrent matters in concurrent jurisdictions. So matters that have the employment aspect to it, that would go to the IDT, and it also has a sexual harassment arm. How Jamaicans for Justice asks that we consider how that would be treated. So those 3 recommendations under Matrix 2.
Senator Gale.
Chair, let me first deal with the Awoja, Ms. Grant, because 34C gives the tribunal the opportunity to make any such other award as may be appropriate in relation to the complainant. So we don't want a situation where we are going to be listing the types of award so detailed and expansive that, you know, someone might say, why you never include this? Give the tribunal the power and the authority to make such determination as it's contained in 34C. Just remind me again, Ms. Grant, about the one now in relation to the different jurisdictions.
Yes, Senator, sure. The provision to address concurrent matters which involve complaints of sexual harassment as well as any allegation of unjustifiable dismissal, where such matters have either started with the Sexual Harassment Tribunal looking at the sexual harassment claim, but it also has the employment aspect to it, and such a matter would go to the IDT. How would we treat with those matters?
So a matter is before the Sexual Harassment Tribunal, and it would be quite unreasonable for another action to be taken against, in this case, it could be the accused, or it could even be the complainant, that it may be dismissal proceedings for whatever the reason. That matter would have to be taken up by the other jurisdiction. Now, is it saying that for whatever the reason, no action, no disciplinary action can be taken on either party who is an employee in an organization, because they may, in the conduct of the affairs, conduct other breaches that disciplinary action may be taken. And it has nothing to do with the case before a tribunal. So they would have to be treated separately. Unless it's a situation where the most unreasonable employer would take an action. Stupidly so, while this matter is before the tribunal and it is in relation to the issue. So if another action is taken for any other breaches, then the Industrial Disputes Tribunal would have to deal with that. But if the matter is before the Sexual Harassment Tribunal, then that course would have to follow suit. And I don't believe we ought to try and make it a complex by inserting a clause that might drag unintended attention to the legislation. So, Ms. Grant, I don't know if that may assist in any way.
Ms. Grant?
Well, Chair, just to say that I raised it, but I don't think it's an issue. Because as you and I both know, Chair, that the proposal initially was to have the two tribunals really housed in one space. And we know what happened there, which is why we're here. Yeah. So if there is an employment-related issue or issues, if there are employment-related issues, then those issues go to the IDT. Where the sexual harassment issues exist, then those come to the tribunals. I don't think it's an issue.
You know, over the weekend, someone challenged me and was pressing that we should just expand the IDT to be dealing with these matters. And I tell you, it was a real, almost a quarrel.
Well, we have all the reasons why.
Yeah. And this has to be, Chair, a part of the education campaign.
Yes, and that will be so.
Yeah.
That'll be so. Branch, so you can continue.
Well, Chair, just to say
Scott Motley, I see where her hand is up.
While Senator Scott Motley comes in, Chair, I just want to put this there about the provision of the mandatory training before the members of the tribunal assume the functioning.
No, please go ahead. I had wanted to ask a question about something I'd raised under the award of the tribunal. I would not want to disturb you. So please go ahead, Ms. Brown.
Thank you. Now, in relation to the mandatory training, some training would be useful. I think that we could consider that. Any comments from members here? While I'm waiting on members to comment, Mrs. Robinson, you may want to contribute here.
Good afternoon, Minister.
Good afternoon.
Sorry, I didn't hear. Could you repeat what you just said, Minister?
Ms. Grant, could you explain on again, repeat that recommendation regarding mandatory training, and so Mrs. Robinson could make a comment on that?
No problem, Chair. So JFJ suggested that we insert a provision that requires each member of the Sexual Harassment Tribunal to undergo mandatory training prior to them assuming their role on the tribunal.
Okay, thank you, Ms. Grant. So in terms of the mandatory training, in the same way that we have the members of the Joint Select Committee sensitized on the matter of sexual harassment and be brought up to speed in terms of what has been done, even the sensitization sessions we've been having and so on, we think it is relevant that the members of the tribunal, when it is so crafted and formed, also be aware of the total parameters of the sexual harassment legislation and everything else that would be pertinent to their role and function. Because at the end of the day, since this is the mechanism that we're going to be using to form, to create the redress for cases of sexual harassment, then it would be in our interest to ensure that such persons are aware. So in the selection of the persons, we are very careful to select persons who would have had, in some case, some shape or form, some awareness on sexual harassment, some exposure to, and based on the breakout of the composition in terms of who is supposed to be selected, we are guided by that as well to make sure that those persons would have had some amount of exposure. But the training is going to make that difference in terms of just giving them the information, because as we are discussing, the tribunal has extraordinary powers. And so we want to make sure that they can exercise their duties and carry out their roles efficiently and informed.
So Mrs. Robinson, are you saying that mandatory training, which would be sensitization or taking them through the basics?
Yes, Minister.
Now, should that be treated as part of the legislation? Is that, Ms. Grant, what Jamaicans for Justice is saying? Yes. Would members, do members feel that that's necessary? Would we want to do that? Dr. Angela Brownberg, I see your hand up.
Yeah, thank you, Minister.
Yes.
I agree that members of the tribunal should undergo, and I'm not even calling it sensitization, I'm calling it training. I believe that we have to see that against the background or in the context of where we are as a country and what the culture has been. And therefore, I believe that we should provide members of the tribunal with the greatest opportunity to really understand what we're talking about, understand what the bill is aiming to do, understand what the provisions are under the bill, and also what the redress is. Quite frankly, I'm not sure if individuals being appointed to the board must have exposure and what that exposure would actually mean. But I do agree that before they assume responsibility as members of the tribunal, that they should undergo that training. In fact, Minister, and this I don't expect to be in the bill, but I'm expecting that certainly ministries, departments, agencies, and the very parliament, not just now the joint select committee members, but every member in parliament should be taken through. And again, for me, it is not sensitization at this level. It's not sensitization because the problem that we have is an endemic one. It is a cultural one for decades. And we have far too many members in high places and quite possibly in our parliament who have no clue about what we're doing here today.
Thank you, MP Brownberg. Senator Donna Scott-Motley.
Did you want my comments on this aspect, Chair?
Yes, please.
I believe that I'm not convinced that it should be in the legislation. I think that it should be done as a matter of course, but I don't see the need, frankly, for it to be in the legislation. I think that it's understood and accepted that the members of the tribunal will be properly prepared for their role once the appointment is made. And as a matter of fact, I'm even, now that I'm thinking about it, I'm a little reluctant to put it in the bill because I think that we should have some level of confidence in how government functions. And if a minister is going to make this appointment, I think that, you know, there are so many avenues that they could utilize. I'm not convinced it needs to be in the bill, but I'm convinced that it ought to be done. And I join with Angela Brownberg in saying that, in fact, all of us should be sensitized about this issue. I have seen some videos which have been done by the Bureau, and they have been amazing in terms of giving you some additional insights. And I think that everybody should be privy to that.
Thank you, Senator Scott Motley. You're saying doesn't need to be a provision in the legislation.
That's actually what I'm saying, Chair.
Senator Gale.
So clause 11 already qualifies those who form the construct of the tribunal. I believe strongly that training should take place. I believe in terms of orientation for anyone who takes up these responsibilities, but I'm not seeing anywhere that it could be placed in the legislation or why it should go in there. But it's a policy decision that training should take place to prepare these members.
Okay, good. Thank you so much. Members, I think members will all agree. Ms. Grant, please go ahead. So you have an understanding, Ms. Grant, of what is the wish of the committee?
No placing in the legislation. Okay.
But as a policy, the training will be done.
And then Matrix 3, these are the two comments. One from Jamaica Network of
I'm sorry, just for clarification, Minister, by virtue of, I'm sorry, let me just put on my video. Sorry about that. By virtue of the comments of the other members, I understand the position about not placing it in the bill and that it becomes a part of policy. I'm assuming because policy is an iterative process, we would have had a policy where we started. I'm assuming, therefore, Minister, that at some point a proper policy document would be drafted that would include some of the things that we are now saying, just for clarity.
There's a very comprehensive policy document, and of course, areas that have been raised here that's not included in the policy.
Okay.
Thank you.
Here, before Ms. Grant goes, may I just make an inquiry? I had raised an issue on a previous occasion, and I wanted to know what the thinking was. I don't think it's going to form part of her report. May I do so, Chair? Because we had actually, Senator Gale had actually alluded to that section. My concern had been, Chair, in respect, the clause 34 makes provisions for certain things that the tribunal can do. It also says it can make such other award as may be appropriate in relation to the complaint. It goes on to say that where the tribunal makes an award for payment of compensation, the sum so payable may be recovered by the complainant summarily in the court without limit of amount as a civil debt. But then it goes on to say that a respondent who fails to comply with an award of the tribunal commits an offense and shall, on summary conviction in a parish court, be liable to a fine not exceeding $1 million or imprisonment and so on. And I had a concern about how that particular clause was framed. I had raised it in a previous meeting, but I don't know if the technical team had taken a look at it to see if this was in fact a clause that should be drafted in this manner for several reasons, but primarily because the awards are, we don't know what kind of awards the tribunal might consider appropriate, and there's no distinction between the awards with the directions and award which they might consider appropriate. So I'd like a response to that, Chair.
Yes, thank you. Ms. Grant?
Okay, so Senate.
Raised previously?
Yes, Chair, I do recall it being raised, but Senator Scott Motley, I just want to make sure I understand. So this is subclause 4 of 34, right?
Yes, correct.
Okay,
That is
and
where criminal penalties arise.
right. And your concern is as it relates to the fact that C gives the tribunal this wide power to make any other award, and then subclause 4 says where you fail to comply with an award of the tribunal, you're saying that there's no distinction with which of those awards, if it would be awards in 34(1)(a) to those are listed awards or any other awards?
That's what I'm saying. And if I'm incorrect, please point it out. And especially as for it's quite specific and says that it can be treated as a civil debt if it's compensation. So I think that clause lacks clarity and lacks certainty. Would you, if you haven't considered it, could you consider it, Ms. Grant? Because I think it's important.
Right, and the other members of the technical team, and then we can come back to that.
Certainly, Chair.
Yes. Thank you, Senator Scott Motley. All right, Ms. Grant, you can proceed.
So finishing up, Chair, Matrix 3, two recommendations made. Jamaica Network of Seropositives proposed that the prohibition of victimization of employees should be considered, and PSOJ asks that the support services be utilized to assist complainants through the process of making a complaint. The PSOJ's recommendation to me, Chair, I think that that's already covered because you have the investigating officer as well as the authorized officer rather, who would be investigating the claim, as well as the complaint form that we had agreed that we would put into a schedule, which would aid the complainant in knowing what form to use, as well as the policy template that we had agreed. So I think those support services would already be included in the legislation, and so those would suffice. So those are the two, Chair, and I'm going to attach another recommendation onto Matrix 3, and those would be the recommendations for Mr. Makulu. When you raised it the last time, Chair, if you recall, members had asked what time to read through the submission. So it was for us to, particularly as it relates to victimization, some members having said that some of the points he made were already addressed by the committee in the deliberations.
Okay, thank you, Ms. Grant. Any comments here? All right, so at this point, Ms. Grant,
Chair.
Yeah, please go ahead, MP Sibley's.
If I may, before Ms. Grant proceed to the point that Senator Motley had raised with regards to the $1 million fine. I don't know if I had missed it, Ms. Grant, through the chair, where there was a group that had make a recommendation that the $1 million be reduced. I think it was a group, the Girls Who Know Jamaica. Ms. Grant, did we discuss their recommendation with regards to whether or not we keep the 1 million or we reduce it? I can recall, and I'm paraphrasing, they had said, the group had said that it really discouraged it would discourage persons from really coming forward. And in the spirit of this committee so far is by way of encouraging persons who have been, who is of the view and who have been sexually harassed to come forward. And so we would not want to not discuss such a recommendation, Chair.
Chair.
Yes, go ahead, Mrs. Celia Brown.
Chair, I think that is for a different point. Clause 34.4 deals with where a respondent fails to comply with an award that is handed down by the tribunal. So that doesn't have anything to do with somebody making a complaint. I think what the member is speaking of is, I don't think we have touched on that issue as yet, is where frivolous complaints. Remember, we had that whole discussion about whether or not a complaint is frivolous or vexatious. And then I think there was a penalty that was attached for making that sort of a complaint, and we were to look at that. But I don't think it relates to what is happening in clause 34, as clause 34 deals with something that is totally different in my view.
I stand corrected.
I think you're talking 38, clause 38, do I?
Yes, I stand corrected, Senator.
They're two separate things. Okay, Ms. Grant, please go ahead.
Yes, Chair. So we're to get back to Mr. Makulu's comments.
Yes.
Right.
Right. So you want to repeat what those were so that the members can make their comments and sign off on them?
That's a problem, Chair. So he spoke to limiting, the definition of sexual harassment is limiting specifically as it relates to the what's listed there, the 5 things listed for what can constitute a sexual advance. And also he said that he thinks the definition for sexual harassment should be expanded to include other unwelcome conduct of a sexual nature. Give me a moment there, Chair. Other unwelcome conduct of a sexual nature. And let me just deal with that while I'm here. Chair, this was brought up in another forum before these comments came. And I recall, Chair, that one of the things that was shown to us by the technical team is that E, as it is now in clause 2, E, that has, where it says sexual advance includes any one or more of the following acts, forms of conduct or behavior, namely, and we go down to E. E says any other physical, gestural, verbal, non-verbal, or visual conduct of a sexual nature. So the complaint was that there, to expand the definition to include any other conduct, but we had said that E would already take care of that. So just to put that in there, Chair, for discussion, and that sexual harassment was too subjective and we needed to come up with an objective test. And the thing about victimization, it was discussed in part, and I remember essentially saying that a person who is victimized has no recourse to go before the tribunal. It is only criminally dealt with under the bill. And I recall the SG indicating at that time, I don't remember her exact words, but saying that it is not necessarily true that victimization is not dealt with anywhere in other pieces of legislation. And she was taking us back to some other pieces of legislation that I can't remember right now, Chair. But those are the 3 points. The fact that sexual advance is a limit, what's contained there, the 5 things, that it is limiting, that sexual harassment is too subjective a test, and that victimization, an employee who is victimized, or anybody who is victimized for that matter, has no recourse to bring it to the tribunal. It is only criminally dealt with.
Okay, and comments? Senator Gale?
Thanks, Chair. In terms of the victimization, yes, there is the possibility that that will take place. And I believe the Solicitor General in one of these discussions had made reference to another legislation when I'd raised it. I don't remember if it was the Jury Act, Solgen, but you did in fact cited a particular clause that would have represented this particular issue and had recommended that the insertion of that particular clause in this to treat with it.
Sorry, if I may at first, I was thinking when Miss Grant spoke, who is that person she's talking about? I didn't remember, but correct, it's the Jury Act, and it was me. And it was the Jury Act. But it was really for the committee to consider. So I don't know if you want me to pull it up and you could.
Yeah, you can pull it up because I was
Give me a minute,
particularly
please.
attracted to what it had represented and knowing very well that there may be these instances where that may take place in terms of possible retaliation, that the provision to protect should be included. In regards to other unwelcome conduct, yes, that has already been dealt with in clause, what was it? Clause
Paragraph E of sexual advance.
Paragraph E, any other physical, gestural, verbal, non-verbal, or visual contact of a sexual nature. So I believe that has been dealt with. But in regards to Mr. Makulu's presentation, a lot of it was dealt with in the legislation. It's only that part that dealt with the victimization or retaliation that we needed to have included as a provision, in my mind.
Yes, Ms. Grant, would you agree? I think we. Oh, Dr. Yes, Dr. Angela Brownberg, please go ahead.
Thank you, Minister. So I was just wondering, in respect of paragraph E on the sexual advance, that spoke about any other physical gesture, verbal, non-verbal, or visual contact of a sexual nature. And just going back to what I hear so often coming from members of the committee about not identifying and describing, that's where you leave it more general, whether or not today, and I really can't think of one, of another description of something of a sexual nature, and whether or not a simpler suggestion as is being made of the unwelcome conduct of a sexual nature would in fact be broader than what is there. So I'm just asking that that question. And then as it comes up, Chair, I was also wondering, you know how we define sexual harassment means the making of any unwelcome sexual advance. I was just wondering whether it is clear in terms of either what we've been used to, as they say, at common law, or specifically in the bill, and understanding that if the sexual advancement is welcome today, and at any point today or tomorrow, it is deemed to be unwelcome, that it is unwelcome. And I mean, I asked the question in terms of what we know to be the culture and the thinking of some, you know, that they're invited in. And since they're invited in, they have to continue because you said yes once. So I'm just thinking and asking for those who might be a little bit more familiar, if that is taken care of.
Comment on that. I saw Mrs. Celia Brown's.
Yes, Chair.
Go ahead.
Yeah, check. Two things for clarifications. I think when we were looking at the definition of sexual advance and sexual harassment, we had decided, you'll correct me if I'm incorrect, Ms. Grant, that we needed to look again at the definition of sexual advance for the simple reason that when we speak of physical contact, we may be infringing on some of the provisions of the Sexual Offences Act, which deals with things like indecent assault. And I think I had made a suggestion that we can use, rather than itemize it the way that we have done, we can use a more general definition, like what I have seen in the Belize Act, which speaks not just sexual advance, but they went and defined unwelcome sexual advance. And it is just conduct of a sexual nature which is unwelcomed, undesirable, or offensive to the person to whom that conduct is directed. And then we have that same subclause to which we have, which speaks to the conduct being made in the presence of a person or a statement of a sexual nature concerning that person, whether the statement is made orally or in writing. And I think if we did that more general definition, that would cover everything we have in B, C, and D, and take us outside of the realm of making sexual harassment just by the definition of sexual advance be somewhat conflicting with a sexual offense under the Sexual Offences Act. So I just wanted to hear my other colleagues' take and the committee's take on that, because I think we are creating some confusion when we speak of physical contact, because that can also be seen as a criminal offense under the Sexual Offences Act. And I think we said that we were going to take out, I'm not sure, maybe I got it wrong, the whole unwelcome sexual advance, or is it that we're saying that that is why we were removing children, because the unwelcome sexual advance as is used in sexual harassment could not have referred to children. I was not clear on that point, but I think we definitely, Chair, would need to look at the definition of sexual advance to ensure that we're not infringing on the provisions of the Sexual Offences Act in relation to some offenses that are there.
Thank you,
Chair.
Thank you so much, Mrs. Celia Brown. Ms. Grant, I don't know if you wish.
Sure, I just wanted to ask Mrs. Celia Brown to repeat which jurisdiction were you referring to just now?
Okay, it's the Protection Against Sexual Harassment Act. Belize, yes, and we define sexual advance, they define unwelcome sexual advance. It means conduct of a sexual nature which is unwelcome, undesirable, or offensive to the person to whom that conduct is directed. So it's clear, to me, it's a little wider. So it doesn't go into all the limbs, and the persons were even complaining that we may forget when you list things like that, it may become a little problematic if it doesn't fall within those limbs, the limbs that we have there listed. And I'm thinking that a definition of that type might be more suitable at this time. And also because of the issues we have with the Sexual Offences Act.
So would you include as well subsection 2 from that same Belize
legislation? We have that already, but don't we have that already? I think we do. Let me look and see. I'm sure we have that. Yes, we have that at the end of our definition clause. If you look at after the definition of worker, we have that same definition. We have that same provision in subclause 2 of clause of bill. So that would take it nicely into defining exactly when we speak of conduct of a sexual nature, what is it we were intending?
I think that we can work with that, Mrs. Celia Brown. I don't hear any objection or comments from members, so I assume.
Sorry, Minister, I have my hand up. Just to ask for some clarity. I just wanted to ask if there is anything wrong with having not an impingement per se, but anything wrong with having something that is making reference rather to conduct that is chargeable under another act. So the fact that it is assault and actionable under other legislation or under common law, does that mean it shouldn't be here? Because the fact is that if it is physical conduct and it is the actual harassment or advance which took place, if it was physical, the fact is that the offended party does have a right of action, even if they do go to the tribunal to take criminal action if they so choose. They may not want to, and or they may. The point is that this act is to give them a particular type of recourse and protection which doesn't otherwise exist where that type of action takes place. So I'm just asking what we're trying to protect against there before we finalize the decision, please.
No, Senator Johnson Smith, my concern is only that because sexual harassment carries civil liability, persons were somewhat, because of the fact that it spoke of physical contact, the whole element of the criminal offense under the Sexual Offences Act was being discussed at all times when we met with persons who were making presentations. And my thing is, I don't know if we would want to, have a conflict with respect to where would that person have redress, whether or not it's a criminal offense or it attaches civil liability. I think because we have offenses that deal with indecent assault and grievous sexual assault in the Sexual Offences Act, I don't know if I just see a conflict if we are going to speak about physical contact of a sexual nature in the Sexual Harassment Act, which only attaches civil liability. That's my concern.
And my question is, if by virtue of its mention, it only attaches civil liability, meaning it will attach civil liability under this act, of course. But are we saying that if you go to the tribunal, you can't bring charges against the person if it is physical? Because if I'm understanding correctly, the wording that you're proposing doesn't exclude it. So I'm asking if the actual manifestation of the harassment is physical, is indecent, gross indecency even, and it therefore is actionable otherwise, criminally actionable. Are you saying that if the person were to seek redress to the tribunal, that they could not seek criminal, to bring criminal charges or have criminal charges brought rather under the SOA?
Well, I'm thinking that is the question that we're going to have to, is it that you can still bring a criminal action even though you're bringing a civil action for sexual harassment?
Well, why not? Why would we be, it never even occurred to me that we would be seeking to say, if you seek redress from the tribunal, then you can't bring criminal action if the activity, if the manifestation of the harassment, if the harassment actually rose to the level of an actionable charge, or rather charge under sexual offenses or offenses against the person, however, wherever it lies in law already. Was that the view of the committee, that it was, if you go to tribunal, you can't bring criminal actions? Because I may have missed that.
That certainly wasn't my understanding as chair.
I mean, if it's a drafting issue and if there's a perception issue about how the act operates, and if you think that it would be better, I'll be guided. I really am just trying, Madam Chair, not to prolong the argument, but to understand it and to understand the thinking behind it. So not only do we get it right, but also so that I can explain it if needs be. I'm trying to follow.
I don't see where it would be a conflict if you take action, civil action, and you also have good reason to take action against the individual on the legislation that is criminal. Is there a conflict? We need guidance here from the technical team.
Before guidance, Chair, because this is where the debate now becomes extremely interesting in my mind. How I thought about it in the first instance is that, yes, if those dealing under the Sexual Offences Act could have gone to the court for this piece of legislation, it makes it a little easier in terms of recourse, and certainly in terms of cost, and maybe in terms of time. So
Yes.
this would have been an easier route. Now, for this matter to have gone before a tribunal, and the tribunal makes an award that in my mind would have been final and binding, then for the person who was the complainant to now turn around and make an appeal through the courts in furtherance of the matter. And remember, Soljen, I had raised the concern in an earlier discussion around the double jeopardy, where the accused would now be facing 2 counts of treating with an offense. And so I am now of the view that I need some guidance in this regard.
Ms. Grant? Can you give us some guidance here?
Senator Gale, your concern is that the sexual harassment allegation would have been dealt with by the tribunal, and then where there is criminal liability, that would be dealt with under the criminal legislation. That's your concern?
No, my concern would have been where the matter of the offense to have been dealt with at the level of the tribunal. The tribunal makes an award which would have been final and binding.
Yes.
And the the complainant would then turn around and make a claim because they felt that they needed more, and it would have been one that would have come under the Sexual Offences Act. Then they are going that route again. So the offense occurs, and it might be one that could constitute the individual going before the sexual offense, utilizing the Sexual Offences Act, but they choose to use the sexual harassment legislation. It goes through the entire process. The tribunal makes an award, and then they now turn around and go to the Sexual Offences Act for further remedy.
And this is in relation to the physical contact.
The physical contact, right.
Yes, I'm gonna invite other comments on this. As you said, Senator Gale, it now becomes really interesting, right?
Yeah, in my mind.
I'm gonna ask Senator Scott Motley. I don't see any hands, but I'm
Sorry, Chair, I think I saw the hand up for Legal Reform Department earlier.
Okay, I'm sorry. Please go ahead. I'm not seeing Legal Reform.
Hello, good afternoon, Chair. I was just thinking that in terms of the concern about the maybe then provision could be made so that the tribunal would take into account any other legal action that was taken in the matter when they're making their decision. Maybe that would address that concern.
Sorry, can you repeat that, please?
Oh, I was just saying that I was suggesting that to address the concern that was raised about an action possibly being actionable under this legislation as well as under the Sexual Offences Act, that maybe what we could do is make a provision in this act that the tribunal take into account any legal action that was taken in the matter in question, in the circumstances that have been identified in the complaint when they're making their decision.
What would that mean? That they would take it into account? Sorry, Chair. I'm sorry. I'm being unruly.
No, you're not unruly, Minister Johnson Smith. I believe you're on the right path in seeking clarity on this, because I don't believe in my mind it was a situation where they would have taken other legal recourse first.
No, I don't think so either.
No. It was, in my mind, to have gone the route of using this piece of legislation, concluded this piece of legislation, and then seek to take action by another means due to the physical contact.
That's right.
So then now go to utilizing the Sexual Offences Act.
Maybe if we can get some guidance. I see SG's hand up and Senator Scott Motley, because I know that there's an order in which criminal and civil, I think, are dealt with. Or let me step down and Madam Chair, I will come in after, please, after some more technical discussion.
Yes, I will take Solicitor General's comments first.
Oh, I would defer to Senator first.
All right, Senator Scott Motley, go ahead.
I was actually hoping that and Ms. Sargent knows this, that her comments would spare me having to make any.
Guess me not us.
My understanding of the question that Senator Kamina Johnson-Smith was asking is that whether both actions could take place concurrently. And I would like her to respond to it so that I know whether my understanding is clear.
No, Senator, it seemed that the position was being put forward that both actions were not available or should not be available, which is something that I would never have, or I had not understood or contemplated. So that the question for me would be, as you are now putting it, is there an order in which it would have to take place? Because it is my view that both should be open, but I am understanding from Senator Gale that might not be the position of all members. And so there's a question of the order, and there's a question of whether it is if you have gotten your settlement at the tribunal, whether you now are stopped from seeking to bring criminal charges.
Well, let me say how I would respond to that. We have agreed already that the time frame for complaint to the tribunal be expanded. In the ordinary scheme of things, we need to recall that in criminal law, there's a standard beyond reasonable doubt, whereas in civil remedies, it is on a balance of probabilities. The normal way in which one would do it, I think, is that you would seek recourse in the criminal courts. And if successful in the criminal courts, the work done by the tribunal would actually be reduced in the sense that the standard of reasonable doubt would already have been satisfied, so that it's easier for the tribunal. The tribunal could take that into account and as part of its deliberations, because the civil standard, which is a standard which we give to the tribunal, is on a balance of probabilities. Now, the reason why I asked exactly what it is that you're concerned with, what would make me uncomfortable is if both actions are taking place at the same time, so that you have a criminal action going and you're before the tribunal. That, I think, would be unacceptable and unfair. I have no difficulty with, if the criminal aspect is completed, they go to the tribunal for compensation or any other sanction. Remember that it is not usual. It can be done in certain instances, but it is not usual for the criminal court to order compensation. Sometimes that comes out of mediation and so on, but it's not really within their remit. That's my view, Senator.
Okay. Solicitor General, you wanted to make a comment, and then
Yes, and I dropped out of the meeting for a little bit. I'm sorry about that. Sorry that I didn't hear all of what Senator Scott Motley was saying. But just on the last point, the criminal court can now do restitution to victims because that was a recent enough amendment to the Criminal Justice Admin Act. Because it was creeping into a few laws like the tip, trafficking in persons, and the lotto scam. And so a more general provision was put in. So actually, the court can make that award when someone is found guilty of an offense. But I just wanted to say the general legal principle, it's not that you can't have both. You can't, it's not that if you have a criminal matter, you cannot have a civil. But normally what will happen is that the courts will take into account. So for instance, if there is a civil matter and then criminal charges are laid, usually the court will take into account what's going on. This is a criminal court. And a lot of times what will happen is the civil matter is put down for the criminal matter to go ahead. So it's not that you can't really have both, but I think the options that are before the committee, I think the option was, is it a deliberate intent of the committee to, for want of a better word, trespass into the Sexual Offences Act by including the physical contact of a sexual nature. So that's the first decision of the committee. If the intent of the committee is clear that you want those matters to also fall within the remit of what's considered sexual harassment, then you perhaps would want to consider having something in the legislation dealing with when you may have concurrent or matters going on at the same time. Because I know how the discussion was going on, but a lot of times, remember, it's not so much that the complainant will decide which legislation to use. When it comes down to the criminal jurisdiction, that decision is also taken by police slash prosecutor. Yes, it is true. If you don't have witnesses, then you have a problem. But sometimes it's not so much that it's the complainant who decides I'm using the Sexual Offences Act and a criminal matter because it can involve other persons and the prosecutor can take a decision at that time. But I think there would have to be a decision about, since we're going in a civil, this is a civil jurisdiction, whether you'd want know how you'd want the courts to treat with it, because it is something that could be addressed in the legislation in terms of priority treatment, whether the criminal matter should go ahead before the civil matter is heard. That is something you could also consider.
Thank you, Solicitor General. I'll take Minister Johnson Smith and then Senator Scott Motley.
Thank you, Chair. I'm going to leave my camera off, if you don't mind, just because I seem to be having slow internet and it keeps interrupting. Okay. So just to say that I think the matter of timing and including something to clarify that issue would be useful. I think that it would concern me. I think we have to remember these things are hard. They're not easy. Bringing an action, whether a criminal action for assault or bringing an action to a tribunal for harassment within your work environment, these are not easy things to do. And I think the type of situation that's going to, that we hope, the framework that we create, we hope will be sufficiently empowering and clear that will allow women to seek, persons to seek redress. Although, yes, I continue to make the point apologetically, it's mostly women who will use this forum and it's mostly women who need it. That they are, we hope that at the end of this committee, the bill that we have is one which will facilitate women taking this action, bringing it to the tribunal and seeking protection and redress. And it is my view that this should not prevent them from bringing criminal action or having criminal action brought if it is that the action were to rise to that level. And so if they were to have brought charges, they should be able to seek redress. And I don't think that if they sought redress and felt empowered or a criminal charge was brought, that they shouldn't be feel empowered to proceed with that as well. The point being, of course, that the issue of concurrence or the standing down of civil for criminal, if that is the way in which they were brought, that those matters should be addressed within the law. But I think saying that you could only do one might create a difficulty. The issue of the physical nature of the harassment, I don't think that I will be contradicted if I say that situations where the harassment is actually physical is likely, at least in the earlier stages, to be the circumstances within which a person will feel most motivated to bring the action in terms of the ability to prove it and otherwise. So I don't think it should be excluded. I just think that the drafting should not be such that it's not permitted to be brought, that if the harassment is physical, then you must proceed to take criminal action, and it is not covered under the Sexual Harassment Act. That is what concerns me. That's what brought me to start to discuss the issue today, because it seemed that that could have been the direction in which we're heading.
Thank you, Minister Johnson Smith. I'm going to ask Senator Donna Scott Motley and then Senator Lockmore.
Chair, I think I want to make it absolutely clear that at no point in time did I contemplate that we would actually be thinking of limiting any individual in terms of the recourse which they would seek to utilize. Absolutely not. That we could not do that. Both options, all options, have to be open to somebody who considers that they have been victimized, abused, or hurt in every way, harassed in any way. My own concern was if it were to be concurrent. And my preference is that, but it's only my preference, that the criminal matters be concluded prior to somebody going to the tribunal, because if we're trying to make things easier for the person who complains of harassment, then that standard, having satisfied the higher standard, it will be easier for them to go to the tribunal. Let us be clear though, and as the Solicitor General has pointed out, I don't know if this is in a case, in a case where the accusation, the complaint is of a sexual nature, that the court would consider restitution. It is not, I think, the practice of the court, but if the Solgel has greater experience, so if restitution is in fact a part of the remedy, perhaps the person won't want to go any further. But for this committee, considering this bill, I want it to be absolutely clear that there was no intention, as I understand it, to confine an individual to one or the other. All options must be available.
Thank you, Senator. I will recognize Senator Longmore and Member of Parliament, Jamaica Davis. I see the Solicitor General's hand is up as well. Maybe I'll take the Solicitor General, then Senator Longmore, and then Jamaica Davis. Go ahead, SG.
Thanks, Chair, although I don't always mind waiting, but thank you. So maybe it is that I think maybe the committee should understand the background of the policy and why this discussion is really coming to the fore. And perhaps you'll then better understand where Mrs. Seeley Brown was coming from and why I asked for the deliberate decision to be taken by the committee. Because at first, it would have started out as a criminal matter, but the bill now is all civil in nature, not criminal. So I think the bigger issue is, should physical touch be excluded from this bill? Because once you include the physical element, you're now wading into the criminal offense territory. So I think that's the issue. And the policy at the time when it became a civil jurisdiction regime was that it really was not going to be addressing matters that fell under the criminal jurisdiction. So I think if the committee is clear on whether the physical touching would be part of the remit of this law, then it means you have taken a decision, and then we would have to then move on from there. As it relates to the issue of restitution, not so much that I have experience because I don't have the criminal law experience, but I can tell you what's on the books. I don't know if it's being used. I don't know if it's being utilized. I think it's maybe utilized in the trafficking in persons, but I don't know if it's utilized elsewhere. But it is on the books and can be utilized. I just don't know if that actually happens in practice.
All right. Thank you, SG. I will now recognize Senator Longmore, MP Tamika Davis, and Senator Cavengale.
Thank you, Chair. My comments on this matter, I am a bit concerned that we are only seeking to address the possibility of the criminal charge based on the physicality of the injury to the victim. As Senator Scott Motley ended her opinion just now by saying that all options should be available. And I think that all options should be available irrespective of whether it is a physical damage or there is an extensive mental component to it. And just to address a little bit also of what Ms. Aldridge just brought up in terms of whether the physicality will almost automatically lead to a criminal offense, I don't think we need to overthink the issue, because we need to be reminded that it is the subjective experience of the victim that I think should guide where we go with this. And when we previously were discussing about the training of the tribunal, I think this is where such emphasis needs to be placed, or a significant part of that sensitization of the tribunal needs to be to recognize when the extent and the damage to the victim is such that it may need to be elevated to the other level of being a criminal, of having a criminal recourse. So my contribution and my concern is that we don't only limit the possibility of the mental effect and the mental consequences to only being pursued as a civil matter. Thank you, Chair.
Thank you. Go ahead now, Senator Gale. No, I'm sorry, MP Davis, and then Senator Gale. MP Tamika Davis, you there? Okay.
Thank you, Chair.
Thank you. Thank you.
All right, so I have a lot of comments really, but let's begin with the physical contact. I think this discussion should always put that contact in context, because the distinction between physical contact under this bill and, for instance, on the Sexual Offences Act is the relations between the parties, between the complainant, perhaps, and the accused. Under the Sexual Offences Act, if it were that we would limit our discussions to the category of persons, let us use employer, employee, it would be certainly easier to prove under this bill if you were to rely on the physical contact. That is to say, it would make it certainly easier for the complainant to bring a matter, whether in a criminal or civil court, if they were relying on this section. So my conclusion is that there's no overlap. There are distinct things, and really it should remain as a part of this bill, because that is the whole purpose of it. We are making it easier for persons who are aggrieved under this bill, under the circumstances we've outlined, to have recourse. And so in that regard, I would say it is necessary and crucial. And really, having listened to all the discussion, I think we can safely conclude that there really is not a conflict. But to go to an earlier point made by Senator Gale, I think the point that he raised was what would happen when the complainant pursues the matter on a civil level, it goes to the tribunal, and they are not satisfied. At that point, can they then turn to the criminal courts and seek recourse? So it is not that they had the option before or thought about it, but that they are dissatisfied, which is a separate scenario. It's a different scenario. And Section 35 says that a decision or an award of the tribunal shall be binding on the complainant and the respondent appearing before the tribunal. And very often when matters go before tribunals, when an agreement is being reached and the parties are agreeing that they have come to some decision, it is usually the norm that they say that this is full and final settlement, or I do not wish to pursue any other remedy I may have, and that forms a part of that final decision. So that was in answer to perhaps what Senator Gale has said in relation to the person who is dissatisfied with what the tribunal has found, and then separate from a person who, the issue that is now being discussed, as Senator Johnson Smith is saying, that they're not two separate things. But really, if we look at it in the context of why we have this bill and the relations, you'll find that the physical contact aids the complainant, making it easier for us to come to some conclusion. And as such, I don't see a conflict really. And I think really too, if the purpose and the objectives of this bill are to be met, then it really would serve us better to have it there. Thank you.
Thank you, MP Davis. Senator Gale?
Chair, can I send MP Davis a virtual hug for representing my concerns so well? Because
as long as she welcomes it.
As long as she welcomes it. But again,
that's
you
a
know,
good
I
one.
would.
Yes.
Thank you. I again so I don't need to repeat what I would have said. The only thing is that having distilled the debate on this, I am of the profound view that we should not take out E in relation to physical contact, because in most instances, in most instances, that act on its own, it is what is going to trigger a complaint, because most of the occasions or occurrences are usually around physical contact and the evidence of such. So I don't think if we take it out, we're going to water down the intent and purpose and scope of this legislation. But again, MP Davis would have represented some of the issues that I would have raised earlier to further amplify what I would have stated. Thanks.
Okay, thank you, Senator Gale. Minister Johnson Smith, you want to make a final comment on this, since you have been very strong on this matter? The fact that members are indicating that they would want the physical to be kept in, and that this piece of legislation would not be limiting the options open.
Yes, I think, thank you, Chair. I think we ended up in a good place. The clarity that we have is positive for the intent. of this bill. The empowering and it's facilitating and it's empowering capacities, I think, are supported by us all agreeing that physical contact should not be removed, that all options should be available to a complainant, and that it will be up to the complainant to determine to a large extent whether it is that they feel that the matter should appropriately be brought to the tribunal within a work environment, and or that it merits criminal treatment as well. So I'm pleased to know that we all are in agreement on that matter, and that the issue would just be to ensure that the actual timing of the actions are preserved. I'm not sure how the guidance will be given in that regard. I heard Ms. Simon proposing that there be language that say that the tribunal should consider any other legal, any other recourse that has been taken. And again, I'm not quite sure what that would mean in terms of constraining the actions of the tribunal or any award that they might give. We recognize now that as has been confirmed, that a complainant could seek compensation through the criminal court if they chose to go through the criminal court. That is, if the action rose to that and could be brought to that level and proved, because we recognize that's a higher standard of proof in the criminal court. Or otherwise, they could, of course, seek recourse through the tribunal if they felt that the options which they needed were best met by the tribunal. So I'm pleased, Minister, that this is where we are, and I would just wait for the final technical summation.
All right, thank you so much, Minister Johnson Smith. Ms. Grant, have you captured all of this?
Well, Minister, I just wanted to be sure there are a lot of opinions as to what the committee has finally decided.
All right, so I'm going to ask Minister Johnson Smith to articulate her summary that she just concluded, so that you can capture exactly the fact that we have the options open, but at the same time, we're not removing the word physical. But I'll ask Senator Johnson Smith to just just summarize it for you to capture as we agree.
But Minister, I don't really need to send it out. I don't really need to write it word for word, just to get the gist that we are allowing physical to remain, so it will not be removed. Yeah. At least that's what I came away with. Senator Johnson Smith?
Yes, sorry. Yes, that's fine. I think there was just a question as to whether anything further was required in terms of the timing of the matters, or if we feel that how the law operates is sufficiently clear in terms of the timing of the matters.
Okay, thank you.
Thank you, Ms. Grant. Okay, so from your end, Ms. Grant, you have completed the general recommendations?
Yes, Madam Chair, that takes us to the end of the general recommendations. One more thing though, Madam Chair, before we move on. I know the Solicitor General had promised to pull up that part of the Jury Act. I think it was 19D, Solicitor General, that part of the Jury Act, just to remind us what she had read to us in an earlier meeting.
Are you ready with that?
Yes, I am.
All right, please go ahead.
I'd also refer to the Protected Disclosures Act as well, but 19D of the Jury Act, it says that let's read it. Where an employee is served with a summons, the employee's employer shall not refuse to release the employee, and then B, do any of the following in connection with the employee providing jury service. 1, deprive the employee of remuneration or other benefits. 2, dismiss the employee, threaten the employee, or threaten the employee with dismissal. Or 3, take any other punitive action against the employee. So I think it's really the things in B1 to 3 that you would be considering. And then it went on to say that an employee who is adversely affected could apply either to the court or to the Industrial Disputes Tribunal for relief. I'd also referred to the and then it also indicated the awards that may be made either by the court or the IDT, which would have been reimbursement of lost wages and benefits as applicable, and reinstatement where the employee has been dismissed due to the employee being summoned for jury service. So that was actually included in this, in the Jury Act as well.
Thank you. Senator Gale, I'm going to ask you to just share this section for me while you have the discussions. And I'll be back in a few minutes. All right. I know you wanted to make a comment.
That's the point of where I'm going to chair and preside over my comment.
You're able to manage that.
All right, Chair. Soljan, in relation to your response, so would this now require a separate clause to be inserted to treat with this, what you would have read out in terms of B of the Jury Act?
Right. I would leave that to Mrs. Seeley Brown, the drafter, to determine whether it would be included in another provision or it would be a standalone.
Mrs. Seeley Brown, would you care to comment? Unmute. You're on mute.
I'll have to look at it and see how best we can insert it.
All right, so we can come back to that then. All right, Mrs. Grant.
One aspect also, though, Chair, was the award that can be made. And the awards included, under jury, it included reimbursement of lost wages or benefits, but it also included reinstatement of the employees. So I think that is something you would need to discuss as well.
Well, so you would have the insertion of the clause if the technical team and Mrs. Seeley Brown would be minded to go there in terms of what action would be taken in relation to any punitive action or damage or victimization of an employee. And then another part treating with the remedies, correct? So in terms of the remedies being the reinstatement, the compensation, but in this case, are we going to align that to the Industrial Disputes Tribunal, as in the case of the Jury Act?
And the Jury Act gave two options, the court or the IDT.
Okay, so we know, Mrs. Seeley Brown, when you get back to us, you may want to consider how you treated one, the action, and two, the remedy.
Yes, sir.
But with respect to Mrs. Seeley Brown, some of that is policy, because if she's going to draft it, she would have to put everything in square brackets then, Senator.
Oh, okay.
Right, she would need the guidance as to what exactly the committee would want to put in the bill.
Any comments, colleagues? Minister Johnson Spitz, Senator Scott Motley.
Sorry,
Senator
Chair,
Longmore.
can I just give you another matter to consider in this
In the
relation
same
to this matter?
vein?
Yes, under the
Right.
Protected Disclosures Act, which is our Whistleblower Act, there is a provision that says an employee shall not be subjected to any occupational detriment on the basis that the person made a protected disclosure. So a protection for whistleblowers. And it then says an employee who is dismissed. So the first thing is the employer is not to subject them to any adverse action.
Right.
And then it says an employee who is dismissed as a consequence of seeking to making or intending to make a protected disclosure shall be treated as being unjustifiably dismissed.
So it was quite explicit.
It said that. That's how it treated with it in the Protected Disclosures Act.
So in this case, for us to take
I'm sorry,
policy,
that triggers. So that triggers a certain type of action.
Yes.
Unjustifiable dismissal. Okay.
Unjustifiable dismissal
Right,
elsewhere. Right. But in this case, it would help the committee. Senator Scott Motley.
Chair, I find that proposal very attractive, the way in which it has been framed in the Protective Disclosures Act, and I think the committee should take a look at it. Because it's clear, and that's what we are seeking.
That one for me hits the point. Without going into much detail, it deals with the action and it deals with the course of remedy.
Right, which I think is very important.
It's important. So for it to be a policy decision then, in order to assist the committee in making a policy decision, would it be helpful for us to see how it is crafted to support the intent and scope of this legislation?
I'm sure the technical team would recommend that.
Yeah. Right. So the only thing I would point out is what's dealt with in a very clear manner in the Protected Disclosures Act is dismissal. What the Jury Act did was dealt with more than just dismissal. It also dealt with deprivation of remuneration or other benefits. And it also spoke about other punitive action. And other punitive action could be,
could be demotion.
You didn't get or you didn't get the promotion.
You didn't get the promotion.
You didn't get, or you could have been transferred, depending on where you work. Because you have these even ministries that have satellite offices and they're in different parishes. You could be moved. So things like that. So I would just say that just consider that as well. That it could be a mix of both of what's in the Protected Disclosure Act and what's in the Jury Act.
And what's in the Jury Act. One of the things you see we'll want to be sure that we capture is any adverse action that would have been taken against the employee. And as you have indicated, it could have been transferred, it could have been denied of benefits, it could have been a denial of promotion, it could have been a bad appraisal.
I'm a little bit confused. I don't know if I missed something. So in the legislation, the forms of sexual harassment and prohibited conduct, does it capture some things like that we're discussing now?
No, what we are discussing now, is in relation to
victimization.
Victimization.
After the tribunal, are you speaking to after the tribunal has ruled?
It could be, Senator Scott Motley, it could very well be when the complaint has been raised or during the process of the tribunal conducting its affair.
Forgive me.
Yeah.
So how do you term where it says that an employer shall not take any action which adversely affects the opportunities, terms, and working conditions of a worker who has instituted proceedings by way of a complaint or claim under this act? or who has given testimony or otherwise participated in any investigation, procedure, or hearing initiated under this act. How do you view that then in the context of how far we have gone in the discussion?
And that would be in 30.
This is 776.
Oh.
726, sorry. 76.
76.
That I think the issue was the awards, and I think
No, it was the award. It
and
was the
also
award.
who would hear the matter, because you see, what had come up before was you go to this tribunal with the complaint. Are you going to also raise with the same tribunal the issue that not only are you now raising a sexual harassment claim, but you're also raising another claim that your employer has taken some adverse action against you because of the claim, and then the issue of the awards.
But isn't there a bar already on the employer doing that?
In 6?
Yes. And wouldn't that be part, if you go to the tribunal, wouldn't that be part of the complaint? That's why I'm asking if what we're discussing, I just want to be clear. What we're discussing is after the award, because I don't, otherwise, to me, that would be part, it would be part, it could form the basis of a complaint to the tribunal that the employer has taken adverse action against me because I've instituted proceedings. I just think that we need to look back at this in light of the discussion we are having to see if we have already taken it into account, or if we need to insert that clause to make it pellucid.
So based on what you're saying, Senator Scott Motley, the only thing that we may need to do is to treat with anything outside of a tribunal making an award, and the action is taken.
Well, the question I have, I take the point that it could be, then the issue is you could bring it, because when I look at you can approach a tribunal for contravention under 7, which is any of the contraventions on
right.
So you could include it at the outset. However, if the tribunal already makes an award, so you didn't include, there was no adverse action against you, and the tribunal then makes an award, can you then approach a tribunal now on this issue?
So Sergeant, that's what I'm seeking clarity on. Okay. Are we contemplating after the consequences, after the award? Is that what we're addressing? Because
let me just say it again, because I see Mrs. Celia Brown furrowing her brow. Just to say, you would have approached the tribunal because someone made a sexual harassment.
Yes.
They advanced. They made an unwelcome advance.
Right.
And the matter went all the way through. The tribunal made an award.
Right.
Subsequent to that, your employer has now taken adverse action against you. And so the issue is, because remember 7.6 talks about that.
Right.
How would you get redress? Is it that you would then go back to the tribunal?
To the same tribunal.
To the same tribunal with this new matter, with this new claim?
Well, that is what
redress there.
Okay, so I start at the position that we have considered. I think the general agreement is that you have 6 years in which to make your complaint. I start with that.
You have 6 years?
That's what I thought was the policy decision.
Yes, that would have been the policy decision.
Yeah. So I have to ask myself whether or not there's opportunity to include this claim of victimization. But let us say that you have proceeded and this new matter arises. that is where I think that we should be that is what I think we should be looking at, because it is clear to me those matters are matters which are prohibited under the already prohibited. So that's why I'm a little lost as to what exactly it is that we are trying to achieve when we're having this discourse.
Yes. Agree, Chair, especially in light of the fact that subclause 6 speaks to who has instituted.
Yeah.
Right.
Yes.
Who instituted.
Mm-hmm.
So what we are saying that it's the same tribunal would be able to deal with the question if the employee would have been dismissed or any action that would have been taken out against that employee.
When that action was instituted based on clause 7.6, yes.
Based on clause 7.6.
Yes, yes.
And so that tribunal can also award reinstatement.
Well, remember the tribunal has wide powers.
In clause 34.
As in 34.
Yes.
As in clause 34. All right.
I just think it is something.
I think the issue had been raised by
thought.
Right. I think the issue was raised by an attorney who sent in a late submission. So maybe Ms. Grant can just check again to see if, I don't know. I'm not sure the context, because I think the attorney had indicated that it was not addressed in the bill. So perhaps
I think it was
didn't see 7.6.
Matondo Makulu?
Yes.
Yes.
That's where the issue came from.
But Chair, if you'll permit me, what I think is that the technical team should probably just mull over it and see, because I frankly think that it is addressed.
Well, now that we have discussed it, in my mind, the fact that we have distilled it and you have pointed us in this direction in terms of what is contained in 7.6, I believe it has been addressed. But in Mr. Makulu's presentation, he was speaking to clause 38.
All right, let's take a look at that.
In terms of victimization.
That's a little different and wider.
Yes, I think it's a
different. This is wider.
Yeah, that's wider and
different.
But I believe in the essence of the discussion, I believe what we are trying to capture would have been contained in 7.6.
I think so. And I think even 38 really is a sanction against the employer too. So that if the employer threatens any adverse action, then there is a penalty which is imposed. So even if the employer believes that or a person, that is how we term it here, that somebody proposes to make a complaint, somebody has given information, somebody proposes to attend, even if they believe that the person has done it or proposes to do it, they commit an offense which is they're liable to a fine not exceeding $1 million or to imprisonment. I frankly think that we have covered the issues which have been raised by the attorney. Mm-hmm. So Jen, I always call your name, right?
All right, Ms. Grant.
Yes, Chair. I agree with what Senator said and what Soljen said. I looked on 7.6 and really the complaint from Mr. Makulu was that victimization has no remedy. It's only treated with as a criminal sanction under 38. But if we go to 7.6 and 7 is captured in other aspects of the bill, then that would take care of that.
All right. Your next point.
Well, that's it from me,
I
Chair.
see. Ms. Simon?
Yes, yes, Chair. It regards to third parties. Legal reform was asked to look at it.
Yes.
So I just wanted to make mention of what we found. I only found we only found 2 jurisdictions addressing third parties. Barbados kind of does it. But what they do, they look at it from the perspective of the employee being harassed by a client. So that's where their provision focuses. So an employee can make a complaint where he or she alleges that they have been sexually harassed by an employee or by a client. And when they do that, the employer then has to take such action as he considers appropriate in the circumstances to bring the matter to the attention of the client, and he should take such action as he considers appropriate in the circumstances to remedy the situation. So their focus is limited as far as third parties is concerned.
But it makes a provision for a trigger on the part of the employer in dealing with third party.
Yeah, where the client rather harasses the employee, but that's their focus. So if you wanted to go wider in terms of some of the other categories that I remember heard mentioned, that might be too narrow. I don't know.
Ms. Grant, could you remind us of those other categories that would have been mentioned?
3 third parties, Chair.
Right.
Miss Simon, that's which clause again?
It's clause 79 in the Barbados employment, sexual harassment prevention.
No, in ours.
For third parties?
Yes. It was to be put in the definition, that's what you were saying?
No.
Suggestion was to expand
third
of the
party.
bill to allow for third parties as categories that are capable of sexual harassment.
Oh, yes. Chair, the categories we're looking on clients, customers. It came out of the recommendation. I don't remember which entity. Clients, customers, where else do I have it? Clients, customers, and people that interact with prone to interact with a business or organization as third parties, Chair. And it was being suggested that we define it. Right, Ms. Simon? Or that we include it in the bill?
Yeah, somewhere, right? So that where I guess if the third party harasses the staff, or I'm not sure if what was also considered was if the staff harassed the third party. I'm not sure if that was what was also contemplated.
No, it was about the third party harassing the staff. So those are the categories, Chair. And you're saying that what you found was a very narrow construction?
It's the word client alone, but I guess it could be changed. We don't have to use the word client. We could use language that is wider so that we could capture some of the other categories. But that's how Barbados approaches it. They give the employee the right to make the complaint where the client harasses them, and then the employer is supposed to follow a certain procedure and take certain action after making their determination.
And which section of the Barbados legislation is this now?
Section 7 to 9. So section 7 is where the employee has the right to make the complaint that they've been sexually harassed by the client.
Yeah.
Section 8B obliges the employer to bring the matter to the attention of the client, and section 9(1)B obliges the employer, after making his investigations, to take such action as he considers appropriate in the circumstances to remedy the situation.
Okay.
And would it be that our insertion for this to capture this particular remedy being,
Chair.
sorry, dealing with
I'm sorry to interrupt. I'm sorry to interrupt you, but I'm just, didn't we agree, or did the committee discuss going a little wider and speak to the provision of goods and services and facilities? When you speak of a client.
In that respect.
Sorry, Erica?
I was just mentioning that Australia covers that aspect. Wider available that we could consider.
Okay, so you had mentioned 28G in Australia.
Not yet. I just mentioned.
I'm sorry. Okay, because I think I was just
Barbados was more.
Okay, all right.
What I was asking is, would this be captured in our 7?
Not currently. You mean when we insert in them, Chair?
Yes.
It's gonna have to be a separate. Well, it will be in the same part, but it will be a separate. It will be a new clause. It will be a new clause. Yes.
Okay.
So the approach that Mrs. C. Brown kind of just mentioned in Australia, which we could also consider, is that they make provision where goods, services, and facilities are concerned. And what they do is to provide in that it is unlawful for a person to sexually harass another person in the course of providing or offering to provide goods, services, or facilities to the other person. And they also make it unlawful for a person to sexually harass another person in the course of seeking or receiving goods or services or facilities from another person. So they also protect the client.
Yes, Chair. Yes, Chair. And I think that provision, I think, is better for us to adopt because it does it both ways.
Okay. And so you're saying to us then that...
It's something for the committee to consider.
And you're saying for us to have a separate clause treating with this?
Well, it's something that the committee may want to consider, yes, and then we would insert it, Chair, as a separate clause. Maybe after clause 7.
After clause 7.
It'll be it can be wider because it can also we can put it after clause 7 or 8.
Right. So after 8, so it would be in the same vein. 7,
Definitely,
8,
definitely.
and then 9 dealing with institutions.
Yes, yes.
Right. Any other area that we needed to have captured, Ms. Grant?
So then, Chair, on the third party issue, so if we're putting it there, well, is it that we'd use the actual word third party? Oh,
yeah, but one would have indicated that would have to define third party.
No,
right,
we don't have to.
I think the language that was being proposed was a bit was different. I think we're taking guidance from the Australian legislation, no?
Right, exactly.
Okay,
Thank you,
that's
Minister
fine.
Johnson.
I just wanted to be sure, so we wouldn't have any need to define third party. No
right.
problem.
Okay. Anything else we're moving on to now, Ms. Grant? You're on mute.
Oh, I see. Minister Grange is back.
Chair is back. Thank you, Chair.
Thank you, Senator Gale. Thank you for holding for me. Okay, so based on the agenda, I think we have some, Ms. Grant, we can go on to outstanding decisions at this point.
Yes, Chair.
Right. So members, you would have your agenda there, and you see that we have outstanding decisions for section 5, 23, 25, 29, 30, 34B2, 34B3, 34.2, and 34.4. So,
and Chair, not to interrupt you, Chair, I don't know if there are any others that I don't know Mrs. McCarthy might have, but those are what I have.
Those are what you have. So we will look at the ones you have. And then we will check with the coordinator to see what else she has. Legal reform, Erica, Could you go ahead? I'm recognizing you. See your hand up.
Oh, sorry, Chair. I should have lowered my hand. I spoke already. It was about third parties when Senator Gale was chairing in your absence.
Okay, thank you. All right, so for clause 5, as it relates to if we're going to commence investigations in 14 days, or if we leave it open by saying that investigation should be immediate and appropriate, we need to make a decision. We need to take a decision on that clause. So I'm inviting members to comment and for us to conclude on that. That's clause 5. So are we going to commence investigations in 14 days, or will we leave it open by saying that investigation should be immediate and appropriate? I'm inclined to say we should leave it open, but I know there are members who were indicating, such as member Brown-Burke, saying, why can't we say to commence in 14 days? I think we have a bit more flexibility leaving it open, but I'm free to listen. Go ahead, Senator Campbell-Rodriguez.
Thank you, Madam Chair. Senator Gale, there's not a bias that I didn't speak while you were chairing, okay? Just to let the records reflect, okay, sir? But
I take note.
Minister, yes. I am still in support of us putting a timeline as to when investigations should begin. I don't believe in putting a cap as to how long it should take, because there are so many variables affecting that. However, I do think we should put some timeline as to when investigations must begin, or if not investigation, proceedings, because that it's not always an investigation. Sometimes it's a form of procedure. So either should begin. I'm even open to it being 3 weeks, but I do believe we should have a time frame.
All right, thank you, Senator Campbell-Rodriguez. Senator Scott Motley.
Chair, I feel that we are going to have to put in a timeline, and I even will go beyond what Senator Rodriguez Campbell suggested by even saying it could be longer. But because my concern is that if we say that a worker who is aggrieved by the failure of the employer to act may make a complaint in respect thereof to the tribunal, we have to give them a time frame within which they can say they are dissatisfied with how the employer has dealt with the matter. I don't think we can just leave it open-ended, because if it's going to be just completely subjective, an employee, a worker might say, you need to do it in 2 weeks, and they're going to the tribunal. You understand what I'm saying? So if we give them a guide, we can make it a long period, but I think we need a period, so that if the employer does not act within a month or 2 months or 3 months, then the worker who considers themselves aggrieved by that failure can go to the tribunal.
I see Senator Campbell-Rodriguez, you still have your hand up, and so fine. Senator Gale, you wanted to make a comment?
Chair, from your acts for the employer to commit to a duty in taking action, it is always important in my mind for that employer to be aware of their scope of permissiveness. Mm-hmm. And one such scope of permissiveness is the time in which that action must be triggered. That's the first thing. The second thing is that if there is a failure on the part of the employer in triggering that action to be determined by a tribunal, then there ought to be some measurement to which that tribunal can make a determination. And so for the proceedings to commence. I'm not talking about just investigation, but for the proceedings to commence, which proceedings may very well include getting reports from the complainant in the first instance, and also any possible witnesses. There has to be a timeline in place. We can just agree on what that timeline ought to reasonably be. But I'm for a timeline against for those instances to which I've cited.
Okay, very good. Senator Scott Motley, you had raised your hand again?
Oh, no, Chair. I take it down right away.
Okay, so can we agree then that rather than saying commence investigations in 14 days is to commence proceedings in 14 days? Can we settle on that? Members?
Madam Chair?
Yes, go ahead.
Minister, I think the legal minds, the legal team, your support team can probably tell us the best word, because I don't know if it's the correct word for an act, even though I suggested it. So, but I just think I agree that it shouldn't be investigation. It should be something about procedures or.
All right, I saw Senator Minister Johnson Smith's hand up, and I want to indicate that I thought I heard Mrs. Celia Brown indicating that if we were specific in dates for the investigations, we'd also have to allow some flexibility in other areas. So I'm going to ask Minister Johnson Smith to make a comment, and then Mrs. Celia Brown.
Thanks, Madam Chair. Could perhaps Mrs. Celia Brown go first, so that if she covers my matter, I won't have to.
Okay, and Minister.
I think, Chair, sorry, Chair, I think that was something that that was an issue that the SG had raised. I wasn't the one who raised that issue, Chair. It would have been Mrs. Aldred.
SG, would you wish to make a comment here?
No, Chair, not now.
Okay, Minister Johnson Smith, over to you.
Okay, Chair. just to say, I'm not objecting to the issue of a timeline, save that, of course, it begs the question of how you then define and what are these proceedings, if you use the word proceedings, where do they end, and how do you ensure that you're scaling appropriately? So if a notice is given to the accused person within 2 days of the report, so I report to you, my employer, that I am being harassed by a colleague, and the colleague is provided notice within 2 days, and then the employer has another 14 days to take action, during which time, so I'm looking to see whether the circumstances that the person who works beside me, who makes my life a nightmare every day, and who is doing so more by his simmering glances and the tension he's creating, while I wait for this hopefully 14 days to elapse for the employer, who I know does not have my back, but who is going to comply just because he doesn't want to fall afoul of the stricture that's brought by the law. So he's going to wait till the 14th day to request a report from either one, which will be neither appropriate or necessary. He has come every day. He has seen the employee beside me every day. He's aware of my discomfort every day. But we have provided for a 14-day period within which this action, the proceedings, can be started. And those are my concerns, that immediacy and appropriateness allow the tribunal to think about what is the circumstance in the wholesale, in the corporate, in the small business with 4 employees, in the school, or you know what I'm saying, to think about the circumstances of the actual employee that's experiencing it and the resources available to the employer and the circumstances of the harasser. And I am guided by the majority view as always, but I look forward to seeing how the draft is put forward, since everybody wants a 14-day period or up to 14 days, no more than 14 days. And then about the language that will complete these quote unquote proceedings to ensure that we're in circumstances where you don't start it within 14 days within the timeline and then let them drift interminably, inappropriately, and without immediacy to completion. So I will be guided by the majority view, but I am quite wary of, well, not quite wary. What if, as long as a framework can be scaled appropriately and that it doesn't inadvertently provide for creative compliance, and that it does in fact protect the victim of the harassment appropriately, then I'll be guided.
Minister
I look forward to seeing what's proposed in draft.
Minister Johnson-Smith, what would you prefer? Would you prefer immediate and appropriate, which you think would allow more flexibility, or at least the immediacy or the urgency?
I think it does, Madam Chair, but I do take the point that there is a need for employer certainty as well, because there's an action that can be taken. There's a duty. It's just that I think that how that duty is assessed, really, I think we have to be very careful in this position. I am listening to the union representative, those in the courts, and the gender development specialists, and trying to be open-minded about the issue, but I just am not getting a great sense of comfort around the timeline that has been put forward, as it has been put forward.
You're not feeling the urgency?
I am feeling creative compliance is what I'm feeling. I'm not feeling the protection. I'm feeling the protection of the employer and not of the victim. That's what I'm feeling. And I just want to be clear that we're finding a balance on both sides. And I know that's the intention of my colleagues as well, my colleague committee members, but I am not hearing it manifest just yet.
All right, thank you, Minister. I will recognize Senator Longmore, then Senator Donna Motley, and then Senator Gale. Go ahead, Senator Longmore.
Thank you, Chair. I share Minister Kamina Johnson's opinion in terms of the concern for the time being somewhat limited in pursuing what might be actually appropriate. So I would like to find a medium where we are assuring the victim that maybe the minimum required time is what is effective. So I'm trying to also find a balance where I would not want for us to use the 2-week minimum, the 2-week minimum, and then lose the full effectivity that we could gravitate for the victim. Thank you, Chair.
Thank you. Thank you. Senator Scott Motley.
Well, let me start firstly, Madam Chair, with the looking at what it is that is required. So it's the direction is that the action must be immediate and appropriate. There is no indication in the bill as to what is considered to be the action. So it is at large as to whether it is that he must start a disciplinary hearing, he must start investigation. What is it exactly that must start? I understand the point that is being made about, I think, I can't remember the term exactly that Senator Kamina Johnson-Smith used, creative compliance. But I still have to look back to the intention, which is to give the worker protection and recourse. And as I've said before, if the worker can make a complaint to the tribunal about the failure of the employer to act, I think a time frame within which we demand some kind of action would be helpful to the worker. So I think we have to take a holistic view of what it is we are trying to accomplish. And whereas I understand the point that Senator Kamina Johnson-Smith is making, I think we have to find some midpoint so that we can really achieve, some balance, having regard to the fact that it is a worker that we are concerned about in passing this Anti-Sexual Harassment Act.
So is there language that perhaps could capture a period of no less than 14 days, but that the tribunal, however, would in all circumstances take into consideration the appropriateness in the circumstances, meaning if it's something that a blind man can see, well, let me use a more politically correct. If it is there are patently obvious circumstances within which proceedings could have been started much earlier and appropriately so, and that was not done, that the tribunal can consider that in assessing whether what was done on day 14 was in fact appropriate in the circumstances, or is it your view that once we have set a period of up to 14 days or no later than 14 days, that appropriateness is no longer consideration for the tribunal in the circumstances?
Senator, Minister Johnson-Smith, your comments are noted. I'm going to Senator Gale.
So I'm here, Senator Minister Johnson-Smith, coming out swinging on behalf of the workers. And in this case, I will not, it is not my intention to protect an employer and expose the worker. I am for, and this is when I smile, when I heard you say no later than, because if the language could have been crafted for the immediate and appropriate action to be taken, but no later than 14 days, it gives in the mind of the employee that there is an established time frame and there's a comfort of that in which they can work. Because we would have seen instances where outside of that, proceedings take place in a workplace that an employer say, yeah, man, I'm going to deal with it. Yeah, man, we're going to deal with it. But there is no time frame in which to hold them to. So we're still suggesting very strongly and encouraging that the immediacy and the appropriate action should be taken, but it can't take place no later than the 14 days. And so that is what both the employee would use as a guide, the employer would use as a guide, and the tribunal in making a determination around the appropriateness can say that, but you had 14 days and you failed to act within the 14 days. So I don't know, Chair, if that approach can be satisfying if the drafting can be done in such a way.
Well, let's ask our technical team to give us their feedback, their response on that. I don't know who wants to take it up. Mrs. Seeley Brown or Legal Reform or SG, who would respond to this? Ms. Grant?
Chair, while they're deciding who's respond, will you excuse me? I have another commitment. And I say that with regret because you know how much I enjoy participating in this discussion.
I know that we're gonna miss you. we're trying to cover outstanding decisions.
Yes, I know.
Because we want to go to the report by next week.
My apologies, Chair. You know that I would really want to be.
I know that. All right, thank you so much for coming. SG? Not hearing USG.
Mrs. Celia Brown is going to speak, Chair, because this is a matter of a language as well.
Okay.
Yeah, we've seen there have been provisions in law like that, Chair, where you said that an action must be taken within some time, not exceeding a particular period of time. So it can be drafted in that manner. If that's yes, Chair.
Okay, and members agree? We can work with?
Sorry, I thought though that the issue also was which proceedings are to be referred to for this 14-day period, because you do not want any confusion with the proceedings that will go before the tribunal. Since investigation was found to be too narrow, if you use proceedings, for instance, then I think you would need to distinguish it from proceedings that are going before the tribunal.
Yes, well, can you assist us in framing, coming up with the right language?
No, well, again, that would go to Mrs. Celia Brown, but I was just saying that would need to be clarified in the draft.
Yes.
All right, but would this be in relation to 5, the duty of the employer to take action in dealing with sexual harassment?
Well, this is why some time ago I was asking to get clarification, because I thought when we were when Mrs. Masada had indicated what we've seen, we were responding to an issue raised in both Clause 5 and Clause 6.
Mm-hmm.
Yes,
Right.
and they were taking action without delay, right?
Right, and remember too, it's two different types of situation, different types of action. So this is why I'd raised it before, and said that you would need to have some amount of clarity when you attach the different timelines to the different types of actions, and perhaps maybe, and I'd come up with saying for those that you weren't going to specify, that you would still need to have some type of timeline, which could be still then the urgent and immediate for the ones you don't specify.
So,
but it's just that if we're moving beyond the proceedings, I would want to make it clear, though, that you're not referring to the proceedings before the tribunal, just so that there's no confusion in the law, because people like to use these things as loopholes to approach the court for interpretation or to create a lot of problems. So I think it's just best to have it very clear, the intent.
Yep. I'll take Senator Campbell Rodriguez and then Minister Johnson Smith.
Thank you, Minister. I just want to get some guidance as to, so in clauses 5 and 6, I see immediate and appropriate appearing 4 times. The term immediate and appropriate. In my mind, in each of those specific places, except for 6.2. So in 5.1, 5.2, and 6.1, I was thinking the 2 weeks could be applied across the board in those 3 areas. In 6.2, however, I mean, we'll just have to reword it to allow to refer to the time frame in the clauses above, in the sections above. I don't know if that's workable. Ms. Aldred.
So, right. So I think, you see, my problem has always been, what is this appropriate action? Because I think it can take several variations and forms, and it was never even ever clear to me, and it was left vague in a way because, again, you can't prescribe anything. So that's understood, and it's not that I am critical of the language, but it's just that when you're starting to put, so yeah, the committee had already agreed on the 2 days to notify someone. That would have been one of the actions. Notification of the, right, okay. Another action, which I know you don't want to use the word investigation, but another action would have been that investigations should, in some circumstances, would be warranted.
No, it have to be used. It have to be used. In this case, once you start
No,
listing,
I think,
investigation would have to
yeah,
be.
but I think Senator Campbell Rodriguez was making a point about if you use investigation alone, you're leaving out a number of other things, which I take that point as well. But I'm just trying to make another point about the different types of actions that you can take. I am not sure though that the 2 weeks is necessarily applicable to everything. And I can't give you an example now, but that was the whole point of using this thing about appropriate action, because we may not be aware, unless we're talking about commencing action, because some action you can't. I'm concerned that we're putting something in and it's not and it cannot be enforced. That's my only concern.
But can we say commencing action? And maybe what we should do at this point is to hear Minister Johnson Smith's comments here, and then we go back to making a decision. Go ahead, Minister.
Oh, yeah, Minister, sorry, Minister.
Minister, it may affect, could you please put your camera on and let's hope it works?
Sure, Minister. I was just going to say, though, that I don't want to prolong the discussion. I think my points have been made, and I think that there is clear difficulty in terms of a timeline in respect of clients and service providers with third parties that we discussed before. So if those are to be treated differently, and that there is language that still includes flexibility, then I just look forward to seeing what that framework would look like. As it is, I see that there will be some challenges. I have to admit some appreciation of that, the broad language used in the Barbadian, or was it Belizean, sorry, legislation, which spoke about, it's Barbadian, taking action without delay or completing the action without delay. I do think and agree that we should not use the word proceedings because it will create confusion. And I think the clear intent of all parties has been that we should have clarity balanced with flexibility. So I just look forward to the proposal from the technical team, because I think at this point we're agreed on the principles, but how it comes together and if that delivers our intention is probably the next point.
Mm-hmm.
Okay, the internet took me through.
Okay, very good. Thank you, Minister. At this point, I invite other comments. I think at this point, I'd like to invite Mrs. Robinson from the Bureau to make her comments. Could you please?
Thank you, Madam Chair. So in terms of the conversation that we've been having, I have been following very carefully and keenly, because I recall last week when we raised this matter, the intention is to ensure that all matters relating to sexual harassment are treated with the urgency that it requires, based on the fact that the victim is ultimately the one who will be experiencing all of the anguish, the pain, the torture, the psychological impacts and so on. And it also depends on what's happening while the investigation is taking place at the workplace, and how promptly the actions will be taken, and what are all of the implications related to this matter. I just want to remind us that the person who has reported the case of sexual harassment might still have to go back to work during the time the investigation is taking place. So if it is we have a prolonged process, then you are prolonging the hurt and the embarrassment and all of that to the person. So I believe, as quite a few persons have said, and especially the Solicitor General, that we should try to ensure that the language addresses the urgency of the matter, so that we take as much as possible swift and immediate actions. So I have no objection with a time frame, but I believe the time frame should be such that it allows for the least moral hurt and injury and harm to all parties concerned.
Thank you, Mrs. Robinson.
You are welcome, Minister.
I saw Ms. Grant's hand up. You want to make a comment, Ms. Grant?
Minister, not to prolong the discussion, but really to say that I don't believe we need to stipulate a timeline for. I know we don't want to use investigations, but I don't think we need to stipulate a timeline. And because as the discussions have shown, it's taken us to a point where it might prove a problem. I think it's wide enough to allow and drafted this way to allow for it to not be of any grave concern. That's just my little bit.
Thank you. So at this point, I'm inviting other comments, please, so we can make a decision. We need the guidance from our drafters. I know. Oh, MP Davis, please go ahead. MP Jamaica Davis, go ahead. Yeah. We're not hearing you.
Unmute your mic. Your mic is muted.
MP, you're having a little technical difficulty there.
Are you able to hear me now, Chair?
Yes, we are hearing you loud and clear.
Okay, great. All right, thank you, Chair. I'm of the view that a timeline is necessary as a guideline when one considers that there are sanctions for not complying. So it is that the employee shall take immediate and appropriate action. And if you fail to do this, then a complaint may be made. So it is going to pose greater difficulty in trying to determine whether or not that has been breached. So immediate and appropriate will need to be defined to make it easier to make a determination whether or not there's a breach. I understand, I've listened to all the comments, and I think what it really comes down to is trying to find that language which allows for us to maintain the urgency while at the same time maintaining a guide, perhaps. That is the best way to really put it. So I think it will inure to the benefit of both parties, both the complainant and the accused person, if there is such a guideline. And I think the greater difficulty would be trying to determine what that timeline is, but certainly a guideline would be needed to ensure that it is complied with. I thank you.
Thank you, MP. I really want to ask the technical. Oh yes, Mrs.
Yeah,
may I suggest? I don't even know at this point if I'm going to be helping. Is it a case where we can say then, since we have an issue as to what may be appropriate action, you can say, okay, you have 2 days after you have received a complaint to notify the accused. I don't want to say the accused, the person to whom the complaint is made against.
Yes.
Then you have within that time, you may have 14 days to commence your investigation of the matter, or you must commence it within that 14-day period. And then everything else you must do, you must take, because we're not sure what else it can be. It could be that the person may be required to go for counseling. It could be anything. So can we say anything after that, the employer must take quick and immediate and appropriate action to ensure that the issue of sexual harassment is being dealt with? I mean, I'm not drafting, but is it along those lines that are you thinking along those lines? Because I'm not clear, I'm not so sure, because the immediate and appropriate action can be anything. because you're speaking of the employer dealing with the sexual harassment at the workplace, not with the tribunal now. I'm thinking that we can probably do it like that. So 2 days.
I think you're on the right track. And if you could just word it accordingly, put something together for our review. Okay. Members would agree? Members?
Yes, Chair. Yes, Chair.
Yes, Chair, I agree with
Yes, Chair.
Okay.
It covers the most immediate actions in terms of priority.
Yes. Okay, great. All right, so we now can move on to clause 23. I'm sorry, clause 6. And that deals with institutions. Read the timeline that we will use to communicate to the accused that an allegation has been brought against such a person.
Chair.
Yes.
May I interrupt? May I go back? I'm sorry to have to go back. Are we, correct me if I'm incorrect. Did we say in relation to clause 5.2 and clause 6.2? And I think it's, yeah. Are we attaching criminal liability where the employer fails to take this action?
It certainly was suggested, Chair.
And if we're doing that, how are we, in light of how we are redrafting, subclause 1, how, where would this, which action will attach criminal liability if we are going that route still?
And what was your understanding based on your notes?
That was suggested, Chair, that we would create a duty and we would attach to the duty, breach of that duty would attract criminal penalties. So what Mrs. Celia Brown is asking in light of the new formulation that we just agreed on, which of those duties then would now attract this criminal penalty? Would it be the failure to communicate within 2 days, or would it be failure to commence investigations within the 14 days and any other action? Which of the 3 would now attract this criminal sanction?
Yes, Senator Gale, please. Thank you, Ms. Grant.
Chair, if we make it a criminal liability, who is going to benefit in this case? Will the proceeds of the criminal instruct benefit the employee who would have been placed in a disadvantageous position in the first instance, as opposed to it being a civil matter where the tribunal could award to the exposed employee? That's my thought. Rather than make it, in the first instance, this legislation is leaning towards a civil proceedings. So in this case, why not make it a situation where the tribunal, in making a determination, can award in favor to benefit the employee, since the employee would have been placed in a disadvantageous position in the first place?
Okay, thank you, Senator Gale. I think Minister Johnson, MP Tamika Davis.
Thank you, Chair. Just to say, I agree with the position held by Senator Gale. It really would inure to the benefit of the complainant for it to remain as a civil liability. As a matter of fact, the proposed fine being awarded is something that really, in the context of the intention of this bill, makes sense.
You and I could make a very good tag team.
I quite agree with you, Senator Gale.
All right, Senator Gale, your hand is still up. You want to continue? Thank you, MP Davis. You want?
No, it's going down, Chair.
Okay. So at this point, I just want to ask Ms. Grant to give us some guidance there from your end.
Well, Chair, it's what is the committee deciding to do? I've heard two members of the committee saying that we should allow the tribunal to make an award and not to criminally address it because it wouldn't inure to anybody's benefit. So I don't have a problem with that approach, Chair. But what do the members say? So two members have said so. So is that the agreement or the decision of the committee?
I see Senator Longmore's hand, and I see MP Davis' hand. It's either still up or she wants to make another comment.
Just to say, Chair, if I may, that I'm in agreement for it to remain primarily a civil pursuit. I think it would be a little bit, I don't want to say heavy-handed, but if just as I was suggesting regarding the offense and what the victim may be experiencing and the potential of that being elevated to a criminal matter, if it is possible that the tribunal can make that decision to elevate the offense that the employer would have been making, if it's such a heinous disregard for the victim who may be suffering at the consequences of the perpetrator, that it could be elevated to a criminal matter, I would go with that. But off regularly, I think it should be a civil matter. Thank you, Chair.
Thank you, Senator Longmore. All right, so I'm inviting comments from other members.
Minister?
Yes.
Yes, I support the view that it should remain a civil matter.
Okay.
I also support the view, Minister.
Okay, fine. So we, Senator Longmore, I see your hand still up. You want to make further comments? Or?
It's going back down, Chair. Going back down. Thank you.
Okay, thank you. So we agree it will remain where the tribunal can award, and it's a civil matter. Agreed? Ms. Grant? You note accordingly?
Yes, Chair.
Okay, so in that case, Mrs. Celia Brown, please advise what would be the changes made, the clauses that you were looking at earlier where you wanted clarification.
Yes, Chair. Chair, what we would then have to do is just link it to where the person can make a complaint. Where we speak to the making of a complaint, we'll have to add those sections. We'll just tweak the language and we'll add those sections to that clause. I don't think that we did initially, and I think that was creating some confusion. So I would just have to look at it again and see. And it speaks generally, so I just have to look at it again and just tweak the language to ensure that an employee knows that he or she, if that employer fails to take that action, he may bring a case against the employer to the tribunal. So I'll just ensure that that is clear in the language of the draft, Chair.
Okay, good. Thank you. Thank you so much. So now we go to clause 23. Ms. Grant, you were going to?
Yes, Chair.
Check on, yes, clause 23.
Yes, Chair. So I was asked to check on the wording being salary. Senator Gale, you'll remember this. Salary, remuneration, whether by way of honorarium, salary, or fees, and such allowances as may be determined by the minister responsible for the public service. I was asked to check on it to make sure that the wording is still current. I looked at Section 34 FB of the Bank of Jamaica Amendment Act 2020, and that wording is still being used. So it is current wording.
Okay, thank you, Ms. Grant. Now, Section 25, the committee discussed, and Mrs. McCarthy wants to ensure that these decisions were reached And I just want to go through those decisions. A, that reports made on behalf of children should be strongly treated with another legislation. The committee discussed that harassment of a child be included in the Sexual Offences Act, where it could be criminalized. Are we all on the same page with what?
I think, Minister, the position was that all of the offences, that any sexual offence in respect of children should be dealt with under sexual offences or child care and protection as appropriate. All the offences against children.
Yes, and that is how you would want it worded. Minister Johnson-Smith?
Yes, and I think, thank you, Chair. I think that was how it had been discussed. And I think I recall Senator Longmore raising the issue of ensuring that 17-year-olds were included, that it didn't stop at 16, etc. So that's my recollection.
In the appropriate wording for the report?
Oh, that I stand to be corrected, but my recollection is that any action which would be sexual harassment of a child or any sexual offense against a child should be treated with under the Sexual Offences Act or Child Care Protection Act as appropriate.
Yes. You got that, Ms. Grant? Okay. And on the section 25 as well, B, to reconcile the jurisdictions between sections 25, 13, and 3 to make sure that the same sections mentioned in 25 are also mentioned in 13 and vice versa. SG, I see your hand up. Go ahead.
Sorry, Minister Grange, it was actually not on the issue you just raised. It's on the matter before about the amendment to the Sexual Offences Act.
Yes.
So that falls under a different responsibility, portfolio responsibility, the Sexual Offences Act, not your portfolio responsibility. It's also not fully the remit of this committee. So what I know has happened in the past is that, and I'm suggesting that you and your committee consider this, that you make a recommendation in your report for the amendment to be considered by the appropriate ministry that has responsibility for it. And then there could be also some discussion with the appropriate minister about it to try and fast track that matter. You see, sometimes it is also very useful to remember that another portfolio, a ministry that has portfolio, you don't know, they may actually be undertaking current research on the matter and they may be doing other things. So it's best to really leave it to them, but you can actually highlight it in your report.
As a recommendation.
Yes, which will now give it even way more urgency to the other ministry and even to cabinet because it's sending a message.
So this would be recorded as a recommendation. So Ms. McCarthy?
Yes, Minister, as a consequential amendment, I have it at the end of the report.
All right, so I now go to B, which to reconcile the jurisdictions between sections 25, 13, and 3 to make sure that the same sections mentioned in 25 are also mentioned in 13 and vice versa.
Just to say, Minister, that from the technical standpoint, that is something that the technical team would do. We'd make sure that the necessary cross-reference is made. So that is something that's easily fixable.
Okay, thank you. Clause 29, PSOJ proposed that proposal indicated that 29.3 be deleted as it makes the tribunal appear that they are set up to mediate and not hear matters. committee said that mediation should remain as remedy under 29.3. Comments there? You want me to repeat? That the PSOJ recommended that 29.3 be deleted, as it makes the tribunal appear that they are set up to mediate and not to hear matters. The committee said that mediation should remain as a remedy under 29.3. So I would need for us to make the decision here.
I'm in agreement with what the committee had indicated previously, Chair. There should still be a remedy to resolve these matters in any way, shape, or form, even if it goes to the jurisdiction of a tribunal.
All right, very good. Any other comment? So it should remain as a remedy on the 29.3. Okay. And that we should
perhaps, Madam Chair, perhaps we could just ensure that in the report, you know, we reflect that that you know, our understanding that the tribunal is not charged with mediation as its sole purpose, as is their concern, but the committee felt that it was still appropriate that that mediation be one of the available remedies. So just to ensure that we acknowledge and that as a policy, or if interpretation ever has to be called into question, that it would be quite clear that this is just part of what it's done. It's charged with doing, rather, as opposed to its key focus.
Yes. Okay. So noted, Minister. And that we should address the typographical error in 29.3 from shall lake, L-A-K-E, to shall take. Regarding section 30, the proposal was made by an entity that the committee should agree on standard of proof. The committee agreed that it should be the civil standard that is on a balance of probabilities.
Agreed, Madam Chair.
Agreed, right. Section 34, committee to agree on how to treat with re-employment of the complainant. Would it be the Guyana or the St. Lucia provision? I don't know if maybe the team could just outline both provisions so we can make a final decision here.
Chairman,
yes.
Last week, Ms. Thompson made a well-researched representation of it. I don't know if it's going to require just a summary. But I have one question in regards to the submission that was made. And I believe it relates to, it spoke about the re-employment and the reinstatement that would have been part of the St. Lucia legislation, if I can recall. But I can't recall hearing if the point about in 34.3 should employ. So I can understand reinstatement and I can understand re-employment, but in the instance where that you're having a recruitment and during the process of the interviewing, the act may have occurred or the complaint came from there. If it was a situation where the tribunal would compel the employer to employ that person if that person was not the most suitable candidate in the mind of the employer. And I can't recall if in the submission it treated with either legislation, either the St. Lucia or the Guyanese legislation had dealt with the matter of employment.
So I'm not sure who would take this from the legal team, but could you provide some clarification here?
Are you hearing me, Chair?
Yes, go ahead, Ms. Grant.
Okay, yes, Chair. Senator Gill is correct in what he said about the presentation made by the AG's chambers. I do have the notes that inform the presentation, and we, well, give me a moment, Chair, please. 30. Oh, re-employment. Right, Chair. We didn't make any decision on it, but I will indicate to you what was said.
Yes.
So the Guyana provision, well, let me start with the St. Lucia. In St. Lucia, sexual harassment is a criminal offense under their laws, and it's treated within two pieces of legislation by them, the Criminal Code and the Equality of Opportunity and Treatment in Employment and Occupation. Their section, that's section 24 of the Act, upon the complainant making an application, that section says that it can order the employer or relevant person to make amends by employing, re-employing, or reinstating the person who was sexually harassed, as the case may be. And the Guyana section, which is dealt with, that section 26 of their Prevention of Discrimination Act 1997, in the Guyana provision, the available remedy does not include employment, but it only speaks to reinstatement. And so it was for the committee to decide which of the two provisions, in light of what these two jurisdictions state, which of the two would the committee be inclined to employ. It was noted by the AGC that the Guyana provision, it's a less harsh requirement, since a requirement for the award of the remedy is that the parties have to agree, whereas the St. Lucia provision is more stringent. So the committee needed to decide if they were going to accept and include the St. Lucia provision by mandating the employer to employ, re-employ, or reinstate the person who was sexually harassed, whereas in the Guyana provision, where they were only going to address reinstatement and stay clear of employment. If you want, Chair, I could read the specific sections for you. Would you wish for that to be done?
Yes.
So this is section 24B of the St. Lucia legislation. It says, an order directing the employer or other relevant person or body covered under this act to redress the contravention, including an order to employ, re-employ, or reinstate any person, although the vacancy in question has already been filled, and although the employer may be liable to any claim arising from the need to dismiss or terminate the services of any other employee who has been engaged. That's the St. Lucia provision. And section 26 of the Guyanese legislation, that's the Prevention of Discrimination Act 1997, reads, without prejudice to any other remedy that may be available in any court, any person who is aggrieved by any act or omission of an employer in contravention of the provisions at part 2 or 3 shall be entitled to apply to the court convicting such employer for any such contravention for any of the following remedies: A, damages from the employer for any loss caused directly or indirectly as a result of the contravention; B, an order directing the employer to redress the contravention, including an order if the employer and the aggrieved person agree to reinstate such aggrieved person.
Thank you, Ms. Grant. Members, may I have your comments on which we will go with? I will ask Senator Gale to certainly open on this aspect of the legislation.
Chair, I must say that for a tribunal in the case of making an award to employ the person who the employer might not have been the most successful candidate is going to pose a challenge. One, it's going to further pose a challenge if that position has been filled. And so you would have to find somewhere to employ that person where if there is that allegation, it's going to create an infractious relationship if the person is employed. Yeah?
Yes.
And I'm suggesting in this case, because I believe the Guyanese one made was it the Guyanese legislation that made reference that if they were both to agree,
yes.
So that gives rise to an either or type of award. Now, if they don't agree, what happens? If they don't agree, if the employer says, I don't agree. Sufficingly to say, I'm of the very strong view that if evidence has been proven, then there should be some remedy for the aggrieved. But to stipulate employment, I have a challenge with that. Maybe the tribunal can make other award under all the listing of awards, but certainly not to compel the employer to employ the person who may not be the most suitable candidate in the first instance. So that's really my thinking.
Thank you, Senator Gale. I'm inviting comments from other members. Please. MP Sibley's, what are your thoughts?
Chair, I agree with Senator Gale on this point, because it is not necessarily the case that the person would be seen as the number one candidate. The person might be competent, but certainly if there are other candidates that are more competent, then it would be something very peculiar to have the tribunal to have that option, Chair. And so I agree with Senator Gale.
Okay, thank you, MP Sibley's. Minister Johnson-Smith, and then Senator Longmore.
Thank you, Madam Chair. Just to ask a question, I've sort of distinguished between what might be appropriate in a small enterprise where the employer is likely to be the person working with the person who applied, and a large enterprise where a decision was taken because a prospective employee refused to comply with some sexual advance. So let us say, so we have created this circumstance where it's an offense for someone to make it a condition of employment that there is some sexual favor that's granted in exchange for employment. And in those circumstances, if that is the headspace, then I would wonder why you would exclude the remedy of the option to be employed. If you have refused that action, and that is the action that allows you to bring your matter before the tribunal, then why would you not want the option? Now, or why would we, not want to grant that option? I see that it would be, there are circumstances where it would be inappropriate, or it would be, if the person could demonstrate that they wouldn't have been fit for the job, they wouldn't have gotten it otherwise. And certainly in circumstances where the employment would create its own toxicity, after the relationship is so poor and it's a small enterprise example, for example, that it wouldn't be an appropriate award for the tribunal. But should the tribunal not have the capacity to make that determination? You know, if it's a major conglomerate and the decision was taken by someone in HR and they don't really have to see them and interact with them on a daily basis, that the right for the tribunal to grant the power, rather, the tribunal to grant an award, including employment, I think would be appropriate. I think to exclude it might, you know, go too far, although I can see in circumstances where it could be problematic. But I would think that would be the discretion of the tribunal.
Okay, thank you, Minister Johnson-Smith. Noted. Senator Longmore.
Thank you, Chair. My comments are a little bit in keeping with what Minister just highlighted. My thinking was, is it possible that the tribunal could make, in developing the policies, could make the recommendation for reemployment or reinstatement? So we're not directly saying that it ought to be, etc., but every case is individual. And I think, again, the tribunal could be given that authority to make the necessary recommendation concerning the specific case. Thank you, Chair.
Thank you. Thank you. Any other comment? So, Ms. Grant?
Sorry, Chair, if I may.
Yes, please.
So what's actually in the bill speaks about employ or re-employ. So the bill doesn't use the term reinstate. I'm not sure if there's a difference with reinstate and re-employ. That I would defer to Mrs. Seeley Brown on. But just to point out to the committee, I think the bigger issue was whether to leave employ in the bill, because re-employ, they're both there already. I think that is really the issue, whether you would remove one. And then I would just ask for clarification whether reinstate is necessary to be included, since re-employ is already there.
Mrs. Seeley Brown? Mrs. Seeley Brown? While we await Mrs. Seeley Brown, Senator Gale, you may want to respond to reinstate and re-employ.
No, re-employ, if re-employ is there, you know, there's no need to have reinstate.
Yes.
Because in effect, you assume the person would have been terminated, and so the tribunal would make the award to re-employ the individual.
Yes.
The question is where you should take out employ. I know I listened to Senator Minister Johnson-Smith, and for it, yes, the tribunal would have the jurisdiction and the authority to make any award under these premises. Now, if I was someone representing the complainant in this situation where the person would be a prospective candidate going through an interview as part of the recruitment, I would argue for nothing else but employment, because there would have been no other reason. If the person says to me, I want to be employed, I feel that I should be employed, I was wronged. And that would place the tribunal in a position to say, this is the demand of the defense. And as a result of that, the tribunal would have no obligation to award employment. I still see it as a little gray area in terms of forcing the tribunal, putting the tribunal in such a position and forcing the employer to employ the person, where at least one legislation makes that part of it absent.
Thank you, Senator Gale. I see Mrs. Celia Brown.
Chair, I'm gonna have to ask for some time to research it because I think there may be re-employ and reinstate may be two different things. They're capable of yes. So I'll have to look at it again and get back to you.
But Mrs. Celia Brown, what we want you to look at is the point that a direction that the respondent should employ.
Remember, we had used that because we had spoken in our legislation about prospective employer and prospective employee. You remember?
Right.
Right, and that I think that is why that was there. But I know we had some discussions about whether we should even speak of the person employing that person.
Yes.
Yeah. So that is the area. That is where I think we needed to have some more discussions, and that was only put in, I think, because we spoke of the prospective employer and prospective employee situation. If you're sexually harassed at a job interview or something like that, and on that basis you didn't get the job.
There is only one distinction for me. So for a first-time entrant for employment, that is where I have the gray area. But if you're already within the employ and you're seeking another job and the act arise, then I can understand the tribunal making an award to employ the person. Chances are, but for the first time, I don't know.
You mean to promote or change?
Promote.
Which is a little different. They're already employed.
Thanks. They're already employed. Thanks, Minister Johnson Smith.
Yes. Do you want go ahead, Minister.
Chair.
Yes, go ahead, Mr.
Chair, at stepped away for a while. So we're going to leave in relation to 34(1)(b)(3). We're going to leave the same language, should employ or re-employ. Is that we're going to still leave? I know we had some discussions about whether it would be wise to ask the prospective employer to employ that employee, that prospective employee. Are we still going to use that? You leave these words here?
Well, that is what.
That's what we just.
That is what we have to make the determination.
Okay.
Right.
Because I'm thinking reinstate can be used where, for instance, somebody may have made a complaint and they may have been demoted. And in their claim, they ask that they may ask to be reinstated to their.
Yeah, they could have been demoted or transferred.
Yes, and that is a little different to re-employ. Re-employ to me, I'm thinking is where you may have been fired, yes. Because you would have complained.
Right.
Yes. So I don't see any harm if we say re-employ or reinstate. But it's just the whole employ when you're speaking of a prospective employee and a prospective employer situation.
Yes.
I think my thing is just that if 7.5 says that a prospective employer shall not make it appear to a person seeking employment that the offer of employment to that person or the terms on which that employment is offered are contingent on that person's acceptance of or submission to sexual advances from the prospective employer, that if the bill is so crystal clear that this is an instance of harassment, it seems to me counterintuitive that the remedy of employment would not be available. It seems to me to flow that in these circumstances, if the tribunal thought it appropriate. So again, I remind my colleagues, and I don't by any means oversimplify this issue, it's hugely challenging. Having an employer employ someone. There are other things that would certainly have to be considered, as has been discussed. But I think that where the policy is so clear that this is an instance, is an offense under the Act, it is harassment in its most bald and exploitative form, that to not allow the tribunal to consider the circumstances and to award employment as or to to order employment as part of its award if it saw fit. So it's not mandating it to order employment, you know, it could only be if the circumstances were appropriate. But it would seem to flow from this 7.5.
Yes. So members, can we go with that?
I can go with that, Chair. If it is going to be worded in such a way that in the circumstances of the situation where the tribunal will have to consider the size of the organization and other things, even in relation to the complainant, because it's the complainant that one would have to consider going into an environment like that. You went for an interview upon being told that you are qualified, you're competent to and being offered this job, and then, however, for you to commence the duty, you need to do X or Y, which is very inappropriate. Well, it left to it left to the size and the kind of culture of that organization as well. Because it might be a large organization, you know, Chair, and even though it is large, because of the culture that exists and the dominance of the person, it may put that complainant in a very, very awkward position when that person is employed. So I agree with Senator Johnson Smith that it should be a point on second thought for the tribunal to consider. However, the tribunal, the bill should be worded in such a way that the tribunal need to consider a number of elements before it would make such award. It would have to take into consideration the complainant, the complainant ability to work in an environment that is conducive to good health and good mental health as well. Those are my submissions.
Thank you, MP Sibley's. Mrs. Celia Brown, you will keep thinking about what has been said, see how it can be done. I'm going to recognize Erica from Legal Reform, and Senator Longmore, you had your hand up. You wish to make a comment, or it's been up?
No, it went down and it came back up, Chair. I just want to also help us recognize.
After you, I will take Mrs. Simon. Go ahead.
Okay. I just wanted to help us recognize that it is not just the capability of the victim being re-employed. It would also be the purview of the tribunal to stop and to encourage and maybe recommend that the person does not go back there for their own safety, in the sense that it could be a circumstance where the re-employment might not be as healthy for them as they may think. And so I think really it should be the purview of the tribunal also to protect the.
I agree with that point, Chair.
Yes, Chair. I just wanted to say regarding the option of employee re-employ being available, just to indicate that Guyana, where the option is for re-employment, reinstatement is based on agreement, they permit, what I would say is that that there can be sexual harassment in the recruitment process for them as well, yet employment is not an option under that legislation. So just to say that it doesn't necessarily follow that because we are making it possible for a person who is seeking employment to make a complaint, that it should follow that the option to employ should be an award.
Okay.
That's one.
Thank you.
Yes.
Are you through, Mrs. Simon?
Yes, I am.
Okay. All right. Senator Gale. I'm going to ask you to make a comment after hearing all the positions that are put forward.
I am still working in my mind, Chair. And even my own thought process, I'm still maintaining that I find it a little challenging to compel the employer to employ this person as part of the award. I can't understand the connection being made in, what was it, 7.5?
Yes.
7.5. But I just want to, and maybe this is where the technical team comes in making the connection to 34.3 as to how it can be tied together.
So maybe I just need to allow a little more time for you.
Yeah, I would allow a little more time.
Yes.
And a little more thought process in it.
Yes. All right. So we will move on to the rephrasing of section 34.2 to read mental and emotional distress. 34.2, mental and emotional distress. We agreed on that?
Yes, Chair.
Right. And 34.4 indicate that a respondent should comply with the award of the tribunal within a certain time limit. 34.4.
Chair.
Yes?
I'm not, but 34.4 deals with an offense and an order by the court, so I don't see how we can put a time limit there. Is that the correct? I don't know if that's the correct provision. 34.4 reads a respondent who fails to comply with an award of the tribunal commits an offense and shall on summary conviction be liable to a fine not exceeding $1 million. So I don't see what time frame we can put there.
Ms. Grant?
Yes, I agree with you, Mrs. Seeley Brown, on second reading, but it did come up in the last meeting and the committee clerk had it down as a point that was not decided on, but I agree with you.
Okay.
Sorry, Chair, if I could just clarify, what this means is if the award is made today and you don't comply tomorrow, then you have committed an offense. I suspect maybe that was some of the concern that they had about the timing of the award. But to me, when the tribunal is making the award, the employer is right there to discuss with the tribunal the timing of it and all of that. Because remember, it's going to be something set out in some amount of detail. So for instance, if we put in reinstatement and because the award could be reinstatement. So reinstatement may take some time.
Or employment.
So I think, meaning that it may not be done tomorrow or it may not be done. So I think what will happen is when the tribunal makes its award, it would have to, in the actual award, it would be saying you must reinstate the employee within, say, 6 months. Or I think that because, for instance, I expect the tribunal would make its awards in the same way a court does. And usually you have to have some amount of specificity when you are doing those awards. The offense would now be committed once there is no compliance with that award. But it's not that the award would just be reinstate the employee. That's it. That's not how it would be. So it would be very specific, and once there is a breach of that specific award, then the offense is committed. I don't think we need to do anything else to this provision. I think it should be left as is. And if the parties before the tribunal are not clear on the decision of the tribunal, then it's up to them to just go back to get clarification from the tribunal.
Okay, so Ms. Grant, have you noted? Right? What's your understanding now where we are?
That it's already covered, and the employer, when the decision is made, I mean, to indicate whatever time frame is needed or so on, and the tribunal will set out their judgment with certain amount of specificity, so we don't need to touch what already exists.
Okay. Okay, so I think we have gone through. Have we covered the list, Ms. Grant?
No, we haven't. We have some more sections, Chair.
But those sections we can take care of at the next meeting?
Definitely, Chair.
Although we really want to wrap up and go to the report in the shortest possible time going forward.
But Chair, can I just ask for one other thing, if it can be just addressed today, because I don't think it should be too much or too difficult or too long. The offenses, because I don't think that was agreed by the committee, meaning you have some offenses set out now in like clause 37, 4, and there were questions about whether it should be the same or not. And I had, in fact, and myself and Ms. Thompson from the chambers had given examples of similar penalties, but the committee needed to take a decision on the penalties. I don't know if you wanted to do that now, or I don't know if Ms. Grant had done a sort of matrix of all the penalties in the bill for the committee to go through. Not sure.
Ms. Grant?
Well, SG, as it is now, remember all the penalties are all 1 million.
Right, but the thing is, there are few. So, for instance, I'd be willing, if the committee wants to just deal with those in 37.4, I can remind the committee of similar treatment, of treatment of similar types of offenses, and you could take a decision at least in relation to those in 37.4, so that we have less to do at the next meeting.
Yes, yes. Let us go ahead with that.
So in 37.4, I had looked at the Commissions of Inquiry Act for 4A. A is interrupting proceedings at a hearing, B using insulting language. And the similar offense I thought was 11.1 of the Commission of Inquiry Act, which is contempt. And under that law, it's $500,000 and in default of payment 1 month. So it's not a fine or imprisonment. It's really a fine, and in default of payment 1 month. So it is different than what you have here. So I don't know if the committee still wants to stick with the $1 million and in default of payment 3 months, or you'd want to have what you have in the Commissions of Inquiry Act, which is an older act, to be honest.
Committee members? You want to stick with 1 million?
It's older, but I think, Madam Chair, it's older, but I think it would be appropriate to make a distinction between those offenses at A and B in particular, and where we can draw a parallel with another act. I think then it helps again with the cohesion of treatment of the offenses.
Yes.
And just to say, Chair, in line with that it was at least 2 entities did indicate that we need to pay attention to the regime and recognize that some of the offenses should have varying penalties. So.
All right. So what is the decision of the committee? What Senator Gale, your comments, and MP Sibley's, MP Davis. So
Sure, I'm always of the view that each act of transgression carries a different weight or should always carry a different weight or penalty.
Okay, thank you. MP Davis.
Thank you, Chair. It seems like we're really doing the tag team. I wish I would have spoken before you, Senator Gill, but likewise, I believe that the 500,000, we want to make a distinction between the offenses that don't go to the substantive matter and that, like in this regard, to the proceedings at a hearing. So distinction, 500,000 to me is in keeping with that view and would really, in this act, show that there's a distinction between the proceedings and the substantive matter. So 500,000 A and B, C, D, E, we could remain with the $1 million.
Okay, and 1 month if you're in default.
Certainly.
Sure. Okay, SG.
Okay, so as it relates to C, publishing anything in contravention of 33 and 33 is where the tribunal would have said, in the interest of administration of justice, etc., there should be no publication of, let's say, name, identity of a person. So right now you still have that $1 million or in default of payment 3 months. In the anti-gang legislation, section 17, it's $1 million or 12 months in prison or both fine and imprisonment. I think you would have to consider the consequences if a tribunal makes an order to say identity is to be withheld from the public, and you think about the nature of the types of matters that would go before the tribunal and the breach. The issue is whether there should be a custodial part to it, not just the $1 million. So, for instance, it could be $1 million or 1 year. And of course, it's all maximum rather than a default. So I think that is what the committee would want to consider.
Mm-hmm. Committee members, your comment, please.
The parallel seems, oh.
Yes, Minister Johnson-Smith.
No, sorry, Madam Chair, I didn't see MP Davis's hand up.
No, it's been up. I think she just forgot to take it down. Go ahead, Minister.
Yes, I support the proposals, Madam Chair. It seems appropriate to align them as have been as has been set out. Yes. I think the distinction between the anti-gang at 12 months and this at 3, I don't know if we would want to go with a middle of the road 6. In fact, because I mean the issue here, the 1 million is appropriate. I think we should keep it. I don't know if I sort of feel that the anti-gang circumstances are a little more intense, yes, for want of a better phrase, than the criminality of that offense versus the circumstances of this might allow for a different regime. So maybe the 3 months could move up to 6, but I'm not sure I would support them moving to 12. But I see the SG's hand up, so I hope yes, I'll get some correction and guidance.
Never correction, not from me. No.
Thank you,
Minister. Chair, I just wanted to, I realized I had omitted something. So I wanted to bring to attention the Child Care and Protection Act, which I think is a little more on point. But before I do that, another big distinction with the anti-gang law is it's not a default payment of fine. It's fine or imprisonment. Here, it's fine, and only when you default payment that you would then have a custodial sentence. But the Child Care and Protection Act, there are certain proceedings where the court may say that identity and so on not to be released or published. And if it's published, the penalty is $1 million, or in default of payment, a term not exceeding 12 months. So the default, the custodial provision is even higher, even in the Child Care and Protection Act. It's higher than the 3 months. So you could decide to also increase. You could leave your scheme, which is a default. If you don't pay the fine, that is when custodial sentence comes into play. But what you could do, as Minister Johnson Smith was saying, you could increase it from the 3 months. So I'm just giving another example. And I think Child Care and Protection Act is a little more on point.
Yes. So maybe we should say 1 million and a year in default. Any comments here? Minister Johnson Smith?
No, and so say all of us, Minister.
Remember, I just share, we all have to be on the same page.
I'm sorry, Minister, which section are we? Which clause is this?
We're
this was 37.4. Yes, this is 37.4C.
Oh, second half.
Oh, C.
37.4C. The publishing anything in contravention.
Okay, thank you.
So I would then go to D, which is permits, divulges, communicates any particulars. And my colleague from the chambers, Ms. Thompson, had advised the committee of 2 provisions. So she had referred to the one I had used before in the commissions of inquiry, which is 500,000, or in default of payment a month. But there is also the Integrity Commission Act that speaks of a similar type of offense. The penalty before the parish court is $1 million or 1 year. So it's not a default. It's 1 million or 1 year.
Well, maybe we should look at 1 million and if default, 1 year. Members?
Sorry, sorry, Chair. No, sorry.
Oh.
Chair, that is actually in relation to 11 to E, not D.
Oh, I see.
E.
Okay. Yes.
So same thing, but it's in relation to E, furnishing false statement to the tribunal. Right. So the Commission of Inquiry Act had it at 11K at 500,000 or 3 months. Integrity Commission, and that's a default, whereas Integrity Commission had 1 million or 1 year. So those are there's some differences.
Yeah, I think that if it's it's not exceeding 1 million and not exceeding 1 year, allows the tribunal to assess the particular circumstances of the falsehood. Its materiality and how egregious it was. So
right, it would be the court. Right.
Yes.
Right. When you say 1 million or 1 year, Minister, do you mean a default or 1 million or 1 year?
I think we can keep the default structure.
Yes.
Yeah.
So this would mean having the default structure running through the entire provisions.
That is what it is so far.
All right.
Yeah.
So the one I don't really have any guidance for is on D. I thought I did, but I don't have the guidance for D. So I guess at the next meeting we could come.
We could come with that.
Yes, we could come with that.
I'm sorry, Chair. It's 500,000 or 12?
No, $1 million.
$1 million.
$1 million. Okay.
But I have to say, Madam SG, through you, Madam Chair, I wouldn't have an objection to this remaining in the same rubric as E, even without a comparable clause, because this is going to be quite sensitive. The nature of the discussions will be sensitive, and the whole point of persons choosing a tribunal as opposed to going to halfway tree parish court is to likely to seek some sensitivity and maybe a little more privacy in the way the matters are handled. So I think it's quite important that the particulars of the complainant being kept confidential is important, and I think it should be treated treated accordingly. So I wouldn't have any objection to the penalty for D being the same as E.
And
I'm in agreement.
The elements would be very similar. I don't want to say the same, but certainly similar. It's the same type of offense. So I understand.
I'm in agreement with that.
All right. So say all of us. Very good.
So that's it. So that's it. From me, Chair.
Okay. Thank you so much, SG. So Ms. Grant, you have all those noted? You've captured all of that?
I believe so, Chair. Let me just go over it again. So this is 37 for A and B, 500,000 or 1 month. Is it 1 month?
Yes, the default is 1 month. Yes.
Okay, 37 for C, D, E, 1 million or 12 months. Okay.
1 million and
1 million or 12 months.
Yes.
Wasn't C 6 months? And D and E 12?
Remember, you had suggested 6, but after that it was compared to, is it the Integrity Commission?
Oh, okay.
Yes.
I didn't realize that. Sorry.
Yeah.
No, the Child Care and Protection Act. That one was Child Care and Protection Act.
Yeah. You got that, Ms. Grant?
Yes, Minister, the fine remains the same. It's the same 1 million or 12, right?
Yes.
Yes.
Good. SG, thank you so much.
Thanks. And if you permit me, I'll also just thank for the record Ms. Thompson, who assisted with this as well from my chambers.
Thank you, Ms. Thompson. Thank you so much. I think that we have done extremely well today. And we have had 18 sittings so far. And we are coming down to the wire. We have other sections too, for us to tidy up, is identify who is a person in charge, especially in terms of educational institutions, where the person in charge can be a managing authority, such as a board or a principal. And so the technical team is to consider who is a person in charge. And also, should a provision be inserted regarding keeping clear, accurate records? The committee suggested creating a standalone provision which creates a duty for keeping of the records, the particulars of the records and how long the records will be kept, duty of confidentiality, and no decisions were taken there. So those are matters that we have to go back to. Senator Campbell Rodriguez, I see your hand up.
Yes, Minister, thank you. I don't know if I think I missed it, and I just wanted to confirm what we had agreed some time ago, I think, on 39.2. If anything, because it was a concern that the penalty there could deter victims, but it probably was handled that week when I was absent. I was absent 1 week. I just want to.
Excuse me, Senator, sorry, Chair.
Yes, Ms. McCarthy?
Based on the decisions, I have the same suggestions from the SG for 39.2, similar to the provisions that she just advised.
Yes, because I didn't know if we had handled it and I missed it in that 1 week, but 39.2 was a concern from before. So I just want to be sure whether or not we had handled it, double check whether or not we had handled it.
Ms. Grant?
Oh, well, I didn't actually make any proposal in relation to that one. So thanks for bringing it back to attention. So I can look for something and get back to the committee next week.
Yes.
Next meeting.
Yes.
Or, I mean, it's similar to some of what we already were looking at, like false statement, but it's a little different. Making false complaints against another person. I think when I looked first, I didn't really see anything very similar in our, in any law. I couldn't think of anything, and I didn't find anything at the time, to be honest.
Madam Chair, because this one is a little different because it could deter victims from coming forward out of fear that they'll end up with this penalty if it's so found that, the situation could just go badly. That's what I'm saying. So I really wish we could look at that one.
But what the committee could consider is maybe lowering the fine to say 500,000 or whatever the committee thinks. And then instead of speaking of a default, indicating that there would be a remedy, a penalty under the criminal justice reform. So, you have like, say, community service or, something else other than, you see, when you talk about default of payment, and going to a custodial. So in that one, it could be treated differently, where you put either a fine or you put another sanction under the Criminal Justice Reform Act. And maybe you could even be specific about which one, say community service, or they have a variety of penalty options under that act, which are not custodial. So that is something you could consider.
With that, with a recommendation as to how we can deal with it?
Yes, I can get back to you.
Would it be that the tribunal would be able to consider the circumstances, and if it were egregious and appropriate for a custodial sentence in default, that it be permitted? And I only ask in the sense of balance. You know how we always get these sort of, no matter how the statistics don't justify it, there's always this concern about false accusations. We had to deal with it under the Integrity Commission Act, I think, as well. The whole issue of making a false accusation. And the need to protect against it, or rather to ensure that they're disincentivized. So I think we can't go too light either. People must feel empowered to come forward with their legitimate complaints. And where people make false complaints, they should bear the consequences of that. Where it is malicious on top of it, then they should bear the consequences as well. So I think where somebody maliciously makes a false allegation and causes damage to reputation and damage people's life, then
Jamaica, home of the resilient, passionate and hard-working. A people and a nation who have achieved and defied all odds, working to keep their economy growing, their country thriving, from investments made in innovative opportunities and exports demanded globally. We have a vision, now within our grasp, where Jamaica becomes the place of choice to live, work, raise families, and do business. We will not let go of this vision. We will grow. We will overcome these challenging times and look to the future with hope and positivity. These are special times. The world as we know it has changed, but home will always be in our hearts. And in Jamaica, you can always find a home. Think you know Jamaica? Look again. You will be surprised.
We work to make communities safer by essentially looking at the structures in the community that contribute greatest to social capital building. Try to reinforce, build, and establish those structures in a way that the community can sustain their own safety and own their own peace. When we say, for instance, we're doing a zinc fence removal program, what we're really doing is improving the line of sight. If you're on the street and you can see better what is behind the fences, then as you walk along the street or children play and etc., you're able to contribute to crime prevention. We believe in terms of our mandate and our responsibility that by making communities safer, we can make Jamaica safer.
Hello, Jamaica. My name is
Jamaica and its workforce are advancing quickly. Life-changing opportunities are arising. You need training and support. We are the Renewed Heart NSTA Trust, committed to providing new and emerging skills training and opportunities. Come to Heart. We'll help you claim your place in the workforce of the future.
Jamaica is a beautiful place. Our people have a beautiful spirit, but we are too aggressive, and the way we interact with our friends and neighbors, I genuinely believe that we have.
And your colleagues, how will they look at an abuser? When the law comes knocking, you'll have nowhere to run.
Mr. Brown, you're under arrest. Please get up, hands behind your head and interlock your fingers.
Turn your back on abusers. Report gender-based violence to the police. There's no excuse for abuse. Call the Bureau of Gender Affairs at 876-754-8577.
The Forestry Department is leading the implementation of the National Tree Planting Initiative, which seeks to plant 3 million trees in 3 years, one for each Jamaican plus a little extra for good measure. So I'm inviting each Jamaican to visit our nurseries across the island and collect your tree seedling and make your mark towards this great goal for Jamaica.
to your mother,
right.
your aunt,
I
your
also
uncle,
want
your
to,
best
while
friend,
we wait, I just want
and
to
they,
quickly
if they don't
give
have similar protection,
the
could fear
committee an
much worse
update.
than you. The second point is, this to my mind is a justification for you to encourage
18
those
sittings.
around you who have not gotten their vaccine to get it when it is available next, and when we announce that the next blitz of a one-type of scenario. It is about protecting all of us, and we are as vulnerable as our weakest individual. And so those who have gotten it, share the experience and encourage others to take it. And also recognize your awesome responsibility to continue to observe the protocols to give those persons protection. And the third point is that the side effects that you have had,
there were
I want the same
491
amount to comment on an element of what was presented earlier by Dr. Ennis.
The
side effects that you have had,
and senior
those
managers would be
135,000.
instrumental in crafting and
You know,
implementing the
I've had
organization
testimonials. I've
sexual
had
harassment
the
policy.
vaccine myself, the first
The
dose.
Bureau also provided
It's not that you have the
technical
virus,
support to 9
as the CMO
organizations
says. That's very important.
regarding the drafting
It is your
anti-sexual
body
harassment
building
policy.
the
We
protection
intend to have
against
this
the virus.
legislation passed
And so
in this
interpret
first
the
quarter.
side effects as a
As chair
positive
of
thing.
the Joint Select Committee
Because
on
what it
Sexual
means, it is
Harassment
that
and
it is
other
building
connected
your immune system.
members, I
It is building your
remain
capacity
committed to making
to
this
fight the
legislation
virus.
a reality.
And so
As
an
members
evening,
of the
a day, a
committee,
night
I wish to
of
remind you
having a
that we are
joint
not just
pain
working to empower
or even a mild
victims
fever
of
or
sexual
a few
harassment,
chills,
but to deal swiftly
you know,
with the
you take the
perpetrators
Panadol,
and get
rest,
them the
relax,
social
overcome.
support
You will get
swift
back to
redress
normality,
which
as all of
they
us
need.
have in this room,
So,
at this table,
at this
who have taken the
point, I would
vaccine,
say we
and the
are just about
135,000 of us throughout the country.
completed
Don't
exercise.
use the side
When we go
effects
through the report at
to
our next
discourage
meeting,
others
I'm hoping
from
that
taking
we
it.
would have been able to
You don't
sign
need
off
to be
on a
graphic
report
or dramatic.
and to
It's a good
finalize
thing
decisions
to have
that
some
were
side effects.
necessary
Don't
to be
use the
made
side
on
effects
any matter that's
to not take the
outstanding.
second dose. Very
And
important.
So
Because
we would be
final
able to
point
table the report
is that, as the CMO said,
within a short
you
time
lose.
after. Mrs. Robinson, I don't know if you want to add anything to my comments here while we await the SG coming back to us, or Minister Johnson Smith coming back to us on how we could look at
None at all.
at 39.2 in order to make a decision. I really would like us to make a decision today on that clause.
Yes, I thought it's Protected Disclosures Act and it's section 20, but I'm just trying to make sure I'm looking in the appropriate. The original offense was to make a false a complaint, knowing that it's false, was $2 million or 2 years. So I'm just trying to make sure that I'm looking at the right version of the law. But I'm
actually looking at that act.
Okay,
Minister,
great.
But I didn't find it. That's the thing. Because I didn't find it in DP, and I was looking at the Protected Disclosures Act, but I don't.
Yes, it's Protected Disclosures is definitely the one that is more on point.
Right,
but
I'm not finding that particular offense.
We'll give you a few more minutes while Mrs. Robinson makes a comment. Go ahead, Mrs. Robinson.
Thank you, Chair. So I'm really just saying thank you for the fact that, you know, persons have been so committed. We have a very committed chair, and that has spilled over to the members of the committee. And I'm really grateful on behalf of all the persons who have had cases of sexual harassment and perhaps did not get the kind of redress or even the attention that it deserved. And so I'm very thankful to the committee for laboring for so many hours, so many meetings. Even when we thought we would have ended on the 31st, we continue to meet. And I'm really looking forward to seeing this come to light because, you know, we have a zero tolerance approach to all forms of violence. And so the commitment continues, and I'm really grateful for everything that has been done. So I look forward, just like the minister and the rest of us, to see this legislation see the light of day. I think you have done exceptionally well, Minister. I have nothing further to say. Thank you.
Okay. Thank you, Mrs. Robinson.
You're welcome.
All right. Senator Gale, you have been a good backup in chairing. So I would want to ask you to make a comment as my backup. Senator Gale? See, my backup is...
Chair, let it be on record. This is the one time you have called on him and he has not responded.
Sorry, was it me?
Yes, it was you.
Sorry.
I'm calling on my backup just to make some comments here because, you know, you represent labor and you also sometimes represent the employer, right?
No.
So I just was saying that I'd like you to make your comment. We're just buying a few minutes until Minister Johnson Smith or the SG comes back to us. For us, I really want us to make a decision on 39-2.
I just stepped away because this was a marathon meeting, Chair, and there are some things that you just may have to step away to do. But let me just say that I believe out of, you know, joint select committees, this has been a very interesting, informative, interrogative type of debate and discussion that, you know, somehow educates us. It has dragged a lot of attention in the public domain. And I believe we are trying to create a piece of legislation that is so far-reaching in the protection of those who would have been exposed to this egregious act at the workplace, in institutions that we are seeking to make the provisions, and in where accommodations are. And I really, really thoroughly enjoy these thought-provoking deliberations and the feedback, the participation from committee members, and the support and also participation from the technical team that no doubt I believe is overwhelmed because of the interrogation and thought-provoking representation from committee members.
Yes, yes.
And I thoroughly enjoy it, and I enjoy your leadership and guidance in terms of us going through this. And I know it's going to be very hard for those who are going to craft the report in terms of going back to putting all the pieces together. And I believe we have done a very good job in, putting things together, not forgetting anything. Both Miss Mack and Miss Grant, in terms of, and I must say also for Miss Rob, who continue to illustrate the work that her unit, her department, her division has been doing. Has been very, very good. I think too, as a labor legislation, this is a key piece of legislation. And when a government comes forward in promoting this type of legislation that is going to protect employment, hands down for me, I give it thumbs up.
Thank you.
I was only using all of that to fill some time, Chair. I run out of speed.
You've done very well. And I see that Mrs. Simon wants to say something, so we will ask her to now make her. Thank you, Senator.
I was just going to say that I found the protective disclosure provision, but it doesn't speak to false complaint. It speaks to the making of a false statement. It does speak to 2 million and 2 years, It speaks to an employee who purports to make a disclosure under this act, knowing that it contains a statement that is false or misleading, or reckless as to whether the statement is false or misleading.
Yes, that is exactly it. It's section 2023.
Right. Yes, but Minister, that is the same as what's in 37.4E, which we just went through. It's not the same as 39.2. That's the thing.
Right, and the Integrity Commission Act has something similar about false statements, but it's not false complaint as well. So Section 43 of the Integrity Commission Act, I'm not seeing false complaint.
Yes, but there's no complaint. There's no complaint here. Here you would be in the whistleblower, you don't make a complaint, you make a statement that accuses someone of something. And if that's false, I am drawing a parallel between that and what would be accusing someone, or rather complaining of harassment, and it's false. That's a parallel that I'm drawing. It's not a complaint because you don't make complaints under the Protected Disclosures Act. You're blowing the whistle
on someone.
So yes, but if you're saying that you don't think that it's analogous, then that's a different position. But I would have thought, and again, I'm not suggesting that it move up to 2 million, but it is a similar circumstance where you have to consider reputational impact. You're considering an allegation that triggers an investigation, and it's not a quasi judicial process essentially. So anyway, we put that forward. It's a 2 million and 2 years is how serious it's considered under whistleblowing, and so that's something that the committee can consider, whether this 1 million and 3 months, which again is a complaint in circumstances where there are confidentiality provisions, but there is possibility for other reputational impact. And in those circumstances is $1 million or imprisonment in default for 3 months, an appropriate comparator to $2 million or 2 years fine, 2 years imprisonment.
Yes. Thank you, Minister Johnson Smith, and I want to thank Mr. Simon and the SG. And I'm going to now ask Senator Campbell Rodriguez. So I see she has her hand up. I just want to say before I hand over to her that it is important for us to consider very carefully the decisions we make here, because when we speak of legislation, we speak also of justice, and we want to make sure that we're making the right decisions and not putting people's reputation at risk. Senator Campbell Rodriguez?
Yes, Minister, thank you. Can I ask then that we put the word knowingly in 39.1? The word knowingly between not and make. Because I think the other act that was referred to, I don't know if one of the persons could read it back to us. I think there's something about knowingly as well there, but I'm thinking that would help in this instance, because then there would be.
There's use of knowingly or recklessly.
Yes, I think if we put the word knowingly there, because then there's a burden to show that, well, I'm hoping I'm correct. One of the lawyers can correct me. If you say knowingly, you then have to show that the person knew that what they were doing was a false complaint. Because I'm just worried.
So agree that it wouldn't be meaning that it's intentional then, that it's not just some kind of oversight.
So that is purposely done.
Disclosure, it speaks about that you have made a disclosure knowing that it contains a statement that is false or misleading, or you have been reckless as to whether it is false or misleading.
Yes.
That's the language in protected disclosures.
Yes, if we could have similar language here, it would sort of help to alleviate the problem that I'm having with this fine, because I'm just worried about, deterring victims.
So you fix your problem then?
I think my only concern with that, Senator, is so in the protected disclosure, you're making you're making an allegation that someone has done something wrong. So this is something which occurs outside of yourself. In respect of sexual harassment, you're making a complaint about an unwanted sexual advance against you. So the person has, meaning there's no recklessness or knowingly or knowledge that needs to be attributed, because this is an offense against your person, which is quite distinctive in the protected disclosure circumstance, which could be about anything. It could be about the company the company producing bleach that doesn't actually work, or medicine that is ineffective, as opposed to knowing that, as opposed to an offense having been committed and not having been committed against you and having said that it was. So I agree with the care that we need to take, that we are not creating fear, but I'm not sure that the language for this for a personal offense, an offense against the person, of which you must know whether it is true or not, is appropriate. But I would be guided. I suppose some belts and braces can hurt, but I'm not so sure that it is.
What if we use, Minister, what if we use purposely? Because what I want to say is, and again, the legal team can help with the proper word, is that your intention was, the victim's intention is not to make a claim that is not true. But what I'm afraid of happening is they go before the tribunal or the parish, you go before the body, and it is found that it is considered that this could not have happened. You could then have a situation where that person knows that something happened to them, but it cannot be proven. And it could be seen as a false complaint. So that is why I understand what you're saying, Minister Jackson Smith, but can we use purposely or purposefully instead? Because we just have to cap that situation happening.
Well,
or mischievously,
or deliberately.
Right, some word is needed there.
I would ask that we ask our technical team to come back to us to see how they can strike that balance. Okay?
Yes, because I think making a false complaint is one thing, and sort of maliciously making a false complaint with malice is another thing. So I think some guidance would be technical guidance. I understand Senator Rodriguez in the same way you understand my perspective as well. So as the chair has said, I guess we can maybe await the technical.
Yes. Well, we have very few matters to make a final decision on at the next meeting. So we really, I think, have made a lot of progress. We should be able to go through the first draft of our report at the next meeting once we get a couple of things that we need to hear back from our technical team and for us to make a final decision on. Team, you have done excellent work. Members, I am so impressed. I think I've had almost 100% attendance at every meeting. It's really laudable. You're all very fantastic, and we have not had any political divide. We all share the same views. We have healthy and robust discussions to arrive at decisions. I think that you have all done a tremendous job. I want to thank you all, and I look forward to us going through the report at the next meeting. and for the report to be finalized so we can table it in Parliament. And I know Minister Johnson Smith is looking forward to taking it at the Senate. Really want to thank you all and be safe until I see you next week. We haven't set a date yet, Ms. Mark?
No, Chair. Based on the schedule for this week, we have a free day on Friday. There's no Senate. Next week will be challenging, so I'm not sure if members would be okay with Friday.
Friday and end before 5, right, Miss?
What time is it? Sorry.
We can try for Friday and end before 5 o'clock. That would be okay with you, Miss Grant?
Yes, Chair. I'm here, Chair.
All right, so we can try.
I have to apologize, though, Chair, because I'm not going to be able to make it.
You're not available on Friday?
That late.
At no time?
That late. If earlier, if the meeting were to start about 10 and end about 2.
We'll start about 10.
Okay.
And what time we end will be entirely up to
this Friday? This Friday, Madam Chair?
What, Minister?
Which Friday, Madam Chair?
Start at what time?
Which Friday did you say, or did I mishear?
Friday coming.
Oh, I think we have legislative committee that starts at 9:30.
Well, Minister Chuck is gone. We should not have a very long meeting.
And the SG, I think, would be.
SG, how are you with Friday after LegCom?
Oh, yes, and also that team I think would be available in any case. Mrs. Masada and Ms. Thompson. Friday, what time? Sorry.
Well, LegCom is at what, 9? Minister Johnson Smith?
I see 9:30 in my calendar.
So what if we plan to start at?
And you're a member of that committee too, Madam Chair.
Yes, I am. So if we were to plan for, if we can put in a good 4 hours minimum, right? So we start at 11 and we end at, we try to end at 4. So MP Siblings would spend a little time with us. He may have to slip out before we end, but we could put in some solid work.
Sure, can we target to end at 3?
All right. I think that once we're able to do some work on Friday, we'll be that much closer to completing the report.
Because what I have to be doing, I have to be pushing meetings. And I'm pushing a meeting again on Friday.
Okay.
Yes, I have at 3 o'clock as well, so I couldn't be possible.
Okay. Senator Campbell Rodriguez, you were saying?
No, I should have taken down my hand. I'm fine with Friday.
All right, so let's say 11 to 3, and we put in some solid work on Friday. Ms. Mark, will that work for you?
Yes, Chair.
Right. So we all 3 members, SG 11 to 3. We will end at 3.
Okay, thank you, Chair.
Okay, good. We can put in 4 good hours of work. All right. So members, thank you so much. Our technical team and Ms. Rob, and you have all been just wonderful. I'm so happy about how much we have achieved so far. Thank you so much. Have a safe, well, I don't know who is in office and who is at home, but wherever you are and you're going to travel safely.
Yes, I'm leaving office now, Chair, so if you don't mind, I'm also going to log off before curfew.
Please do, and get home safely.
Thank you.
And all of you, please take care.
Thank you, Chair.
All right,
Be well, everyone. Bye.
All right.
Keep safe, everyone. Bye.
Bye, Chair. Bye, everybody.
Bye. Bye.